Students are joining. We'll start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. Yesterday, we initiated a discussion on judiciary. Supreme Court at the top, then High Courts, then District Court, and then the Gram Nyayalayas. First, we'll focus on the Supreme Court. Under Article 124, Clause 1, there shall be a Supreme Court headed by the Chief Justice of India and not more than 7 judges. But these judges can be increased. The number of judges can be increased. And for that, Parliament has to pass a law by simple majority. This law shall not be deemed as an amendment to the Constitution. And right now, we have the Chief Justice of India and 33 other judges. Then what is the qualification in order to be appointed as the judge of a Supreme Court or the judge of a High Court? For the Supreme Court, you should be the citizen of India and a judge of 1 or more high courts for 5 years, or citizen of India and an advocate in 1 or more high courts for 10 years, or citizen of India, or in the eyes of the President of India, you are a distinguished jurist. For a high court judge, you should be the citizen of India and must have held a judicial office for 10 years. If not, then you are a citizen of India and you are an advocate in 1 or more high courts for 10 years. There is no concept of distinguished jurist when it comes to the appointment or the qualification of a high court judge. Then how are these judges appointed? Initially, the ultimate power was with the executive, because the Constitution said every judge of the Supreme Court and High Court shall be appointed by the President. And while appointing a judge, the President shall consult such of the judges of the Supreme Court and High Court as he may deem necessary. But whenever a judge other than the Chief Justice of India is to be appointed, the Chief Justice of India shall always be consulted. And when a judge to a High Court is to be appointed, the governor of that High Court should always be consulted. And then there was this convention that we were following, that the senior most judge of the Supreme Court was appointed as the Chief Justice of India. But this convention was broken. In 1973, Justice A.N. Ray superseded 3 seniors and was appointed as the Chief Justice of India. And those 3 judges, they resigned. 1976, Justice Khanna was superseded. He was the senior most judge of the Supreme Court. He was not appointed the Chief Justice of India. Instead, Justice Beg, who was at serial number 2 in terms of seniority, was appointed as the Chief Justice of India. And then these matters were heard by the Supreme Court, first judges, second judges, third judges, fourth judges cases. And the ultimate picture right now is that we have a system of collegium, where India is perhaps the only country where judges are appointed by themselves. Collegium consisting up of Chief Justice of India and senior most judges of the Supreme Court. If we have to appoint the judge of a Supreme Court, then this collegium will have 4 senior most judges of the Supreme Court apart from the Chief Justice of India. If the President has to appoint the judge of a High Court, then the collegium will have the Chief Justice of India and 2 senior most judges of the Supreme Court. If the judge from one High Court to another High Court is to be transferred, for that we need the Chief Justice of India, 4 senior most judges of the Supreme Court, and 2 Chief Justices of the concerned High Court, sending state and the receiving state. And in all this, Chief Justice of India enjoys a veto, because any name which is not acceptable to the Chief Justice of India cannot be sent to President for appointment. And the Supreme Court said in fourth judge's case, which is also known as the NJAC case. In this case, the Supreme Court said primacy of Chief Justice of India. Primacy, basically the veto of the Chief Justice of India in judicial appointments, is also part of basic structure of the Constitution. But now what has happened is that ideally any judgment given by the Supreme Court, Article 141 says, is the law of the land. And what do we have to do with the law? We have to abide by that law. We have to follow that law. But now there is a tussle, a clash between the executive and judiciary. Particularly on this, judicial appointments. Mr. Gopal Subramaniam, a senior advocate of the Supreme Court, one of the top constitutional lawyers in India, one of the top. He was also assisting. He was an amicus curiae in the Gujarat riots case. Horrific riots broke out in 2002 in Gujarat between the two communities, and then the case went to the court. The court appointed an amicus curiae. And who is this amicus curiae? Amicus curiae is the friend of the court. Who is your friend? Somebody who is assisting you in your civil services preparation. He or she will check your answer copies, will guide you what is the real situation when it comes to current affairs. Somebody who acts as your guide, somebody who's your friend. Similarly, when the court is hearing a particular matter, in some matters, the court asks, as senior advocate of the Supreme Court, can you please assist us in this case? And that individual is known as the amicus curiae. Gopal Subramaniam, he was appointed as the amicus curiae, as the friend of the court, to assist the court in this Gujarat riots case. And then after some time, he was recommended by the collegium as the judge of the Supreme Court. And if he was appointed, then over a period of time, Mr. Gopal Subramaniam would also become the Chief Justice of India because he had age on his side. Ultimately, his name was not cleared by the executive. Executive did not appoint him. When executive did not appoint him, ultimately what happened? Judiciary did not reiterate his name. Because any objection on a particular name, the executive has to tell the judiciary in writing that these are our objections. And because of these objections, we will not appoint this person as the judge of the Supreme Court. Can you please reconsider? But if the same name is reiterated again, then the government has no other option but to appoint that individual. But in case of Mr. Gopal Subramaniam, he was not reiterated, he was not re-recommended by the collegium, and ultimately he was not appointed. When he was not appointed, there were a series of recommendations made by the Supreme Court collegium, and we have absolutely no idea why executive did not appoint them. Even judiciary did not tell us. There is no transparency why the executive is not appointing these individuals. So this leads to a question of independence of judiciary. If independence of judiciary is part of the basic structure of the Constitution, if any judgment given by the court under Article 141 becomes the law of the land which has to be abided, why is it that this collegium system, which was started in 1993, reiterated in 1998, reiterated in 2015, why is this not being followed? We have no idea. or at least till recent times, we had no idea why executive is not appointing a particular individual, despite the fact that there are some names which are pending before the executive for a year, for 10 months, for 6 months, for 8 months. Now, what has happened for the first time ever? For the first time ever, the judiciary, the collegium system, on its website has listed reasons why executive is objecting. This has never happened in the past. This has happened now for the first time under the Chief Justiceship of D.Y. Chandrachud. 3 names were recommended by the Supreme Court Collegium to the President of India. That what you have to do, you have to appoint these individuals. Who are these individuals? Mr. Saurabh Kirpal. His name was recommended by the Collegium to be appointed as the judge of Delhi High Court. But his name was not approved by the executive. Previously, we would never know what are the objections of the government. We have absolutely no idea. But now, for the sake of transparency, judiciary is now listing on its website what are the objections raised by the executive. And the judiciary says, executive is objecting to Saurabh Kirpal, who is the advocate of Delhi High Court, to be appointed as the judge of the Delhi High Court because he is openly gay. And his partner is a Swiss national. On this ground, the RAW has rejected his nomination, which basically means Collegium recommended a name to the executive. Executive has the option that you can ask the Collegium to reconsider this name. But on what grounds? The grounds should be written. Initially, we would not come to know what are the objections raised by the executive. And now the judiciary on its website has listed down what are the objections of the executive in appointing Mr. Saurabh Kirpal. And the government says Saurabh Kirpal is openly gay and his partner is a Swiss national. So it is basically a danger if this individual is appointed as the judge of the Delhi High Court. Now, what has happened? Supreme Court Collegium has now reiterated his name. Saying even if he is openly gay, Section 377 has been decriminalized. Homosexuality is not a crime. So on this ground, why are you having objections? And if his partner is a Swiss national, Switzerland is a friendly country. So what should be your objections if this individual is appointed as the judge of the Delhi High Court? We are reiterating his name. Despite reiteration, the executive has still not appointed. Matter is before the court. The court is asking the executive, why are you not appointing these individuals when we reiterate this name? Don't trick us into taking this matter in our own hands. Which means if this clash is not resolved soon, maybe right now, at least the president issues a formal appointment letter on the recommendations of the Collegium and appoints judges to the Supreme Court and High Court. If the executive even then will not appoint these individuals, maybe the Supreme Court will even snatch that power from the president and will issue appointment letter on its own and appoint Saurabh Kirpal as the judge of the Delhi High Court. That should not happen because that would be classic violation of the separation of powers. But for that, judiciary and executive, they have to come together, cool their heads, and try to come up with a consensus. Should this document be made public? As citizens, we should know what are the objections raised by the executive about a particular nominee. So for the sake of transparency, this document is necessary to be put in the public domain. But there are also others such as Pratap Banu Mehta, one of India's foremost political scientists. Pratap Banu Mehta says this should not have been made public because ultimately it is a first step towards a further clash between the executive and the judiciary. This sensitive material, this sensitive information should not be leaked. Why? Because that is for the executive and the judiciary to decide behind the closed doors. On this ground, we should not have objection. Plus, something else has happened. Despite collegium, executive still has a say in controlling the judiciary. How? For example, Mr. John R. Sathiam and Miss Victoria Gowri. Listen to me carefully. Both these advocates of the Madras High Court, clear? Recommended by the Supreme Court Collegium to wear as the judge of Madras High Court. Just like Saurabh Kirpal, advocate John R. Sathian, his name was also not approved by the executive. What were the reasons? The reasons given were, now we know because it is on the website, the reasons given was that Mr. R. John Sathian, he had tweeted an article of Quint.com, which was critical of the Prime Minister Modi. He had also tweeted in favor of a girl who committed suicide when she failed to qualify the NEET examination in Tamil Nadu. And he criticized this, and he criticized the political class for failing to protect that girl. On these grounds, we think he is not suitable to be appointed as the judge of the Madras High Court. Just like Saurabh Kirpal, the name of John R. Sathian has been reiterated to the government of India, but the president has still not appointed this individual. Miss Victoria Gowri, she was previously part of the BJP. She was also an advocate of the Madras High Court. Now her name was recommended to the president for being appointed as the Madras High Court judge by the Supreme Court Collegium. And once her name came out, there were a series of reports in the newspapers which said that Victoria Gowri, she had allegedly made hate speeches against the Muslims and the Christians. Can this judge, who is openly speaking about two communities, can we expect this judge to be fair when she is presiding over the bench of the courts? On this ground, she should not have been considered. Matter went to the Supreme Court. Supreme Court rejected this petition. Supreme Court said, no, we can only look at whether she was eligible or not. If the collegium has decided that she is eligible, she is suitable, we cannot override the recommendation of the collegium, which primarily means Miss Victoria Gowri can be appointed as the judge of the Madras High Court. And immediately, very quickly, in no time, the president issued an order. Victoria Gowri was appointed as the judge of the Madras High Court. In this case, what happens? Two things are important. One, same allegations. One allegation is slightly serious. If an advocate tweets an article which is critical of Mr. Modi, it is not a crime. But when you give hate speech, it is a crime. So out of these two individuals, if you ask me, Mr. John R. Sathian should have been appointed. Ms. Victoria Gowri should not have been appointed because it sows the seeds of distrust amongst the people. If I approach this judge, I would know what kind of speeches she has made. Maybe I will hesitate to come before her. Justice should not only be done, it should be seen to be done. But now in this case, if these objections were reversed, if the allegation against Mr. John were allegations against Ms. Gowri and vice versa, you would have seen that the government is appointing Mr. John as the judge and not Ms. Victoria Gowri. That's problem number one. So what suits the government, that individual is appointed. So despite collegium, executive is still controlling the judiciary. So where is the independence of judiciary? That's problem number one. Problem number two, seniority is an important principle. because a senior most judge is then eligible to be appointed as the judge of the Supreme Court and then appointed as the Chief Justice of India. Seniority is very important. If there is a list given by the collegium to the executive that these individuals are to be appointed, Mr. John Sethian's name is at a higher level, at a higher serial number than Miss Victoria Gowri. What executive is doing? Picking and choosing. Pick Miss Victoria Gowri and not Mr. John, which basically means tomorrow Miss Victoria Gowri will become senior. If at all Mr. John is appointed as the judge of the Madras High Court, she becomes senior despite the fact that her name was recommended later. This is another way of executive controlling the judiciary. Now the matter is before the court. Now the court will have to decide what will we do in these matters when we recommend names to the executive. Executive is raising the objections. We are reiterating the name. Even then the executive is not appointing. Can we also snatch the power of appointment from the president and issue the formal orders on our own? That we will have to wait and see. And that is what you need to understand regarding the appointment process of the judges of the Supreme Court and the High Court. Done? Okay. Now let's look at how the judges of the Supreme Court and High Court can be removed, because the process for both these judges is the same. I've told you that judges of the Supreme Court and High Court, they enjoy something known as security of tenure. Security of tenure in the sense they don't hold office during the pleasure of the president. I am the judge. I am not giving a favorable judgment in favor of the executive. President can remove me. That doesn't happen. Because the judge of the Supreme Court holds office till the age of 65. The judge of a High Court holds office till the age of 62. But even before that, they can be removed. Removal is important. Why? Because this is how we can keep a check on the executive, how we can keep a check on the judiciary. For example, there is a judge who has been appointed, but now this appointment we are regretting. Why regretting? Because the judge is not attending the meetings of the benches. He's not participating in the judiciary. He's giving judgments, but horrible judgments. He's indulging in corruption. This individual should be removed even before completing the tenure of 65 and 62. For that, the Constitution has made a possible situation. The situation is these judges of the Supreme Court and High Court can be removed. How? For that, President has to issue an order. So who has appointed judge of the Supreme Court and High Court? President. The appointing authority becomes the removal authority as well, which means the judges of the Supreme Court and High Court shall be removed by the president. But how can the president remove a judge? If a resolution is passed by both houses of the Indian Parliament by special majority. Special majority means 2/3 of the members present and voting plus majority of the total membership of the house. That means 2/3 members present and voting plus absolute majority. If both Rajya Sabha as well as Lok Sabha pass a resolution, and this resolution becomes what? This resolution is basically a statutory resolution. And we know statutory resolution is binding on the president. If this resolution is passed by both houses of the Indian Parliament by special majority, then it is binding on the president to remove the judge of the Supreme Court and the High Court. But on what grounds can the judge be removed? On the grounds of misbehavior or incapacity. But these charges should be proven. What is misbehavior? Can be sexual harassment, can be corruption. What is incapacity? A judge was appointed, he was healthy. But now after the appointment, suddenly the judge turned insane, mental unsoundness. And because of that, he is not able to give good judgments. Then what do we do with this individual? we will have to remove him. How can the judge of the Supreme Court and High Court be removed? By the president, not on his own, on the basis of the resolution passed by both houses of the parliament by special majority. On what grounds? On the grounds of misbehavior or incapacity. You are now incapacitated to give the judgments. But these allegations should be proven. But Constitution does not talk about how these charges are to be proven. And for that, we have a law. And what is that law? Judges Inquiry Act of 1968. The process is not mentioned in the Constitution. Constitution only says the judge of the Supreme Court and High Court shall be removed by the president based on the resolution passed by the parliament on the grounds of misbehavior or incapacity, which should be proven. But how do we prove it? What is the process that needs to be followed? For that, the law has been passed by the parliament known as the Judges Inquiry Act. And what is this Judges Inquiry Act? For example, we have to remove a judge. This process can be initiated in either Lok Sabha or it can be initiated in Rajya Sabha. Let's say it's Lok Sabha. 100 members of Lok Sabha will write to the Speaker. Dear Speaker, we have to remove a judge. Okay. When the Speaker hears this petition, looks at this motion, gives 14-day notice to a judge. Judge, be ready. You are about to be removed from your office and the allegations are misbehavior and incapacity, and these are the allegations. If the Speaker is satisfied that yes, these allegations are serious, what the Speaker will have to do? The Speaker will have to set up a committee. What is this committee consisting of? This committee will have the Chief Justice of India or his nominee, will have the Chief Justice of a High Court, will have a distinguished jurist. Now, this 3-member committee, which has been set up by the Speaker, will have to investigate all these allegations of misbehavior and incapacity against a judge. And after that, this committee will submit this report. And then this report is presented before the Lok Sabha. When Lok Sabha looks at this report, then there will be voting on this motion. And if a special majority is obtained, then this motion will travel to Rajya Sabha. Rajya Sabha will also look at these allegations and ultimately vote. If Rajya Sabha also passes a resolution by special majority, matter will go to the president, president will sign this, and the judge is removed. Or if we can reverse the process, the process may initiate in Rajya Sabha. Now 50 members of Rajya Sabha will write to the chairperson of Rajya Sabha, sir, we have to remove a judge. Okay, I will give that judge a 14-day notice. Once the chairperson is satisfied the allegations are serious, then he can set up a committee. This committee will have the Chief Justice of India or the nominee of the Chief Justice, Chief Justice of a High Court, and a distinguished jurist. And ultimately, this committee, these members will investigate the allegations against a judge. Then the voting will take place. If voting takes place in Rajya Sabha by special majority, then in Lok Sabha by special majority, and then in the same session, this should be sent to President for assent. What do we mean by same session? This is very important for your prelims. If, for example, this is the budget session, and in the budget session, Rajya Sabha members are writing to the chairperson, or Lok Sabha members are writing to the chairperson, to the speaker. If this is a budget session, in the same budget session, this process should be complete. And in the same budget session, you have to send this matter to the president for removal. If it is pending, it won't lapse. You will take it up in the next session. But then in the next session, the entire process has to be completed in one go. That means both Lok Sabha as well as Rajya Sabha will pass a resolution and then send to the president in the same winter session. And then the president signs and the judges of the Supreme Court or High Court can be removed. But till date, no judge of the Supreme Court or High Court has ever been removed through this process. We had a case of V. Ramaswamy. He was the Chief Justice of Punjab and Haryana High Court. Then he was appointed as the judge of the Supreme Court. While he was the Chief Justice of Punjab and Haryana High Court, it is alleged that he misused the public money. He used the money, which is public money, he used that money to renovate his personal home, private home. Basically misbehavior, corruption. Matter went to the parliament. The Lok Sabha passed a bill, passed this motion calling for the removal of this judge. But in Rajya Sabha, the Congress party abstained. When the Congress party abstained, that means in Rajya Sabha, we could not get the special majority and Justice Ramaswamy was not removed. Then we saw Justice Sumitra Sen of Calcutta High Court. He was all set to be removed as the judge of the Supreme Court. But then judge of the Calcutta High Court. But then he realized that I should not enter the history books as the first judge to be removed by the parliament. Before he was to be removed, before the voting could take place, he resigned and ultimately saved himself from disgrace. But the bigger example is that of Chief Justice of India, Justice Deepak Misra. Justice Deepak Misra was the Chief Justice of India. And as the Chief Justice of India, there were a series of allegations against Justice Deepak Misra. Who leveled these allegations? Not me, not you, not politicians, not media, collegium. Who were members of this collegium? Chief Justice of India is part of the collegium. And then we have 4 senior judges of the Supreme Court. Who are these 4 senior judges? Justice Ranjan Gogoi, Justice Chalameshwar, Justice Kurian Joseph, Justice Madan Lokur. 4 members of the collegium, they are leveling serious allegations against the Chief Justice of India. How? They addressed a press conference in January 2017. Unprecedented, historic press conference, which we have never seen in the history of independent India. And these 4 judges of the Supreme Court are saying democracy is in danger. We wrote series of letters to the Chief Justice of India so that you can mend your ways. But he's not listening to us. Now we are accountable to the people of this country. And through media, through this press conference, we are telling the people of this country that democracy is in danger. What were the allegations against Justice Deepak Misra? Series of allegations. One big allegation was that of bench fixing. Bench fixing in the sense, these 4 judges of the Supreme Court collegium, they said important matters, important cases involving the executive, where the members of the executive, where some ministers are concerned, these important cases do not go before us. They're not assigned to us. These important cases are assigned to junior judges. And some of these junior judges are known to be close to the executive. So Chief Justice of India is the master of the roster. What is master of the roster? Chief Justice of India is the head of the judiciary, but he also has an administrative role. What is the administrative role? He has to assign cases to all the judges of the Supreme Court. That is what we call master of the roster. He starts this roster system. Roster system in the sense that whenever a public interest litigation is filed, these will be the judges who will hear this case. A criminal case is filed, these will be the judges who will hear this case. A taxation matter is filed, these will be the judges who will hear this case. Because all the judges, they will have expertise in their own domain. Somebody would be very strong in civil laws, somebody very strong in constitutional laws, somebody very strong in criminal laws, somebody very strong in public interest litigation. So now the Chief Justice of India, being the master of the roster, will assign cases to individual judges or individual benches. He will set up a bench that this is the 2-judge bench which will hear this case. This is the 5-judge bench which will hear this case. And these 4 judges of the Supreme Court are saying that Chief Justice of India is basically doing bench fixing. He is assigning important, sensitive cases involving the executive to junior judges who are known to be close to the executive, not to us. That is why democracy is in danger. Although they did not refer to this, but their grouse was because of Justice Loya. Who was Justice Loya? There was an allegation of fake encounter in Gujarat. The accused was the then Home Minister of Gujarat and the current Home Minister of India, Mr. Amit Shah. Clear? Now, since this matter was in Gujarat, we could not expect justice in Gujarat because the judiciary is in Gujarat, the case is in Gujarat, he's an important minister in Gujarat government. Then Supreme Court transferred this case to Maharashtra. And now in Maharashtra, we have a judge, Justice Loya, who is hearing this case. Who is the accused? Mr. Amit Shah. Matter went to Justice Loya. Justice Loya is looking at all these allegations. According to some, Justice Loya was approached by somebody showing him a paper that this is what your judgment should look like. So you have to exonerate, you have to acquit Mr. Amit Shah. How do we know this? Because there was an investigative report published in the Caravan, published in the Wire.com, Wire.in, and some other websites. It is argued that Justice Loya had revealed this to 2 of his friends. To 2 of his friends, he has revealed this matter that I am being pressurized to acquit Mr. Amit Shah. And then Justice Loya, he had to participate in a wedding of a friend's daughter. Then when he was participating in that wedding ceremony, suddenly he felt chest pain and then he died. When he died, there were a series of questions raised on his death as well. Why was he not taken in a government car or in the official vehicle? Why was he taken in an auto or a different vehicle to a very far off hospital, not to the nearby hospital, to a hospital where there is no ECG machine? And when the judge was pronounced dead, why were the members of his family not immediately informed? So on and so forth. So many allegations were raised. But Justice Loya had revealed that matter, that somebody is approaching me, asking me to give a favorable verdict, to 2 of his friends. What happened to these 2 friends? One friend, he was at the top floor of the judicial complex of the judiciary, this district judge, and ultimately he fell from the top floor and committed suicide. Dead. Another individual who was in touch with Justice Loya, who according to newspaper reports, Justice Loya revealed to him what are the pressures on me, pulls and pressures on me. This friend was traveling in a train. He was seated at the top berth of the train. Suddenly he fell, fractured his neck, and he's also dead. It's like a classic Bollywood movie. Series of objections were raised. Ultimately, petitions were filed in the Supreme Court that please conduct an inquiry into the unfortunate sudden death of Justice Loya. This case was heard by Justice Deepak Misra. Justice Deepak Misra rejected this petition, saying there is no need to conduct an inquiry. Why there is no need to conduct an inquiry? Then quickly, some people got to know what is the matter. In a sense, they pricked, investigated, and got to know what exactly is Justice Deepak Misra doing. They realized that there is a bribery case. And this matter is right now before the court. Private Medical College, recent current affairs development as well. Private Medical College in UP. The court in UP said that this private medical college cannot carry on admission because they lack infrastructure. Medical Council of India says this private medical college does not have the required facilities to provide training to the future doctors. That is why from next year onwards, you cannot go ahead with your admissions. According to some newspaper reports, this owner of the private medical college, he was approached by some judges. that give us something and we will give you a favorable verdict in the Supreme Court. Two judges approached him, according to newspaper reports, and now the government has given sanction to one judge investigate allegations against him. One judge was Justice Kudusi of the Odisha High Court. And ultimately, it is argued that bribe was taken, bribe was given, and these judges took this bribe so as to give a favorable verdict in favor of this private medical college. And later on, Supreme Court said, no, this private medical college can go ahead with the admission. Medical Council of India is wrong. And who was the judge who presided over that meeting, who presided over that bench, who decided that, yes, this private medical college should go ahead? Justice Deepak Misra. So basically, if you look at it in common sense, executive knows everything. What is happening in judiciary, what is happening in legislature, what is happening in India, what is happening in my home, the executive can know anything. If it wants to know, it can know anything. So there are judges who may not be so pure or so proper or so honest. They would have some elements of wrongdoings. And now those wrongdoings will be used by the executive as blackmail. Do this, otherwise this case will be reopened. Do this, otherwise we will investigate this matter. And that is how the judges, they crawl, they bend, they genuflect before the executive. When all this came to light, these four judges of the Supreme Court addressing a press conference, which never happened in the history of independent India, and they are leveling allegations against their own Chief Justice. Then what happened? When the opposition heard and listened to that press conference, they approached the chairperson of Rajya Sabha. For the first time in the history of independent India, the members of the parliament introduced or tried to initiate a process to remove a sitting Chief Justice of India. There have been instances previously where we wanted to remove a particular judge of the Supreme Court or a High Court, but never against the Chief Justice of India. Now, more than 50 members of Rajya Sabha are writing to the chairperson of Rajya Sabha. Mr. Chairperson, Mr. M. Venkaiah Naidu, come here. I said, what? These are more than 70 members who have written. We want to introduce this motion, and this motion, we want to have the discussion in the Rajya Sabha because we want to remove the Chief Justice of India. What is the process? Rajya Sabha will investigate, Rajya Sabha will initiate, or Lok Sabha will initiate. Now Rajya Sabha has initiated, and this motion has been sent to the chairperson of Rajya Sabha. Please accept this. This is where the presiding officer has a discretion. He may admit this motion, he may not admit this motion. And the chairperson of Rajya Sabha rejected this motion, saying there is no basis to introduce this, we will not go ahead. And ultimately, the proceedings against Justice Deepak Misra stopped because the chairperson of Rajya Sabha has the discretion to either accept or refuse to entertain this motion. Then opposition could have thought of approaching the court. So if the chairperson has done something which they think is illegal, which they think should not have happened, which they think should have been accepted by the chairperson, then what is the alternative? Go to the court. And as soon as they tried to go to the court, they saw Justice Deepak Misra. So how can we complain against the chairperson of Rajya Sabha to the Chief Justice of India when the matter deals with the Chief Justice of India? And ultimately, opposition said, let's drop this matter. And Chief Justice of India, Justice Deepak Misra, continued and finished his term. But why are we discussing this? Removal. What is removal? The judges of the Supreme Court or High Court can be removed by the president on the basis of the resolution passed by both houses of the Indian Parliament by special majority. On what grounds? Proved misbehavior and incapacity. But how does this process initiate? For that, the law is passed by the Parliament known as the Judges Inquiry Act. According to this law, what is the procedure that we have to follow? If 100 members write to the Lok Sabha Speaker, or if 50 members write to the chairperson of Rajya Sabha that we have to remove a particular judge, when this motion is given to the presiding officer may either accept this or refuse to entertain this motion. If you have accepted this, then this presiding officer will set up a 3-member committee. This three-member committee will consist of a Chief Justice of India or the nominee of the Chief Justice, the Chief Justice of a High Court, and a distinguished jurist. Then this committee will investigate matters of misbehavior and incapacity and then submit report. If the report is submitted, on that there is voting. If the special majority is obtained, matter goes to the other house. If special majority is obtained, then in the same session, the matter should be given to the president. President has no other option but to sign, and the judge of the Supreme Court or High Court can be removed. And till date, there is no judge who has been removed through this process. Judges have resigned, but no judge has been removed through this process. Any questions? Let me know. This discretion of speaker, it has Rajya Sabha or Lok Sabha too. The presiding officer, whether the speaker or the chairperson, they have a discretion. Sir, after Justice Loya's death, what happened to Amit Shah case? The court then said, Mr. Amit Shah is acquitted. You're free. If the judges violate the constitution, we can say that this is misbehavior because you don't have to violate the constitution. On that ground, they can be removed. But if the question is asked specifically in your prelims examination, on which of the following grounds is the judge of the Supreme Court or High Court removed? And if one ground is violation of the constitution, mark it incorrect. Because constitution says the judges of the Supreme Court and High Court can be removed on the grounds of misbehavior, incapacity. If Chief Justice of India himself is removed, then the next senior most judge of the Supreme Court will be part of this committee. In Lok Sabha, 100 members are required. That's what is mentioned here. For Lok Sabha, not less than 100. For Rajya Sabha, not less than 50. Okay. Now, Constitution says under Article 30 that the seat of the Supreme Court, what is the seat of the Supreme Court? Where the Supreme Court will operate from. The Supreme Court will operate from Delhi. Now listen to me carefully. Or in such other place or places. Now what's the difference? I'll tell you. Under Article 130, the Supreme Court may sit in Delhi or in some other place. That means not Delhi, then Chennai. Or in some other places. That means in Delhi, as well as Chennai, as well as Guwahati, as well as Raipur. Can be at one place, can be at multiple places as well. But what is the procedure to be followed? If the Chief Justice of India, with the prior approval of the President, will appoint from time to time. That means right now, the seat of the Supreme Court is the Supreme Court will sit in Delhi. Can it be shifted from Delhi to Calcutta? Yes. Who will decide that? Chief Justice of India with the prior approval of the President of India. Can the Supreme Court sit in Delhi as well as Kolkata, as well as Chennai, as well as Bengaluru, as well as Guwahati? Yes. If the Chief Justice of India with the prior approval of the President decides and appoints from time to time. Why is this significant? Now listen to me carefully. We have the Supreme Court in Delhi. Clear? But I am from South India. Let's say I am from Kanyakumari, or I am from deep northeast. Let's say I am from Itanagar. I am from Arunachal Pradesh, deep in the northeast. Matter is before the district court. District court says you are guilty. You have lost your case. I approach the High Court. High Court also says you are guilty. We will not help you. Then what I have to do? I have to approach the Supreme Court. When I look at the Supreme Court, see, it is in Delhi. Now I start taking out my phone and I calculate the costs. Boarding, lodging, travel. I have to take my lawyer from Chennai, from Kanyakumari to Delhi, all the expenses of this lawyer. Then in the Supreme Court, I have to hire another Supreme Court lawyer. All this cost will add up to, but I'm very poor. How will I get this money? I will drop this case. I will not approach the Supreme Court. Is this not violation of justice? Why should justice only be given to those who can afford a lawyer, who can have money so that they can travel to Delhi? The very fact that the Supreme Court sits in Delhi makes it evidently clear that the Supreme Court is inaccessible to a vast majority of our population, particularly in South India, particularly in deep Northeast, who will have no money to bear all these expenses so that they can get justice in the Supreme Court. And for that, there were two solutions prescribed. Which were these two solutions? Solution number one was we should have regional benches. Regional benches in the sense, we will have the Supreme Court in Delhi, but we will have Supreme Court in northern, eastern, western, and southern India as well. Let's say we can set up another regional bench in North India, let's say in Chandigarh. In East India, let's say in Calcutta. In West India, let's say in Gandhinagar. In South India, let's say in Chennai. So that Supreme Court becomes accessible to every single Indian in India. Because, for example, if you are from Hyderabad, or if you are from Amravati, or if you are from Cuttack, you cannot go to the Supreme Court in Delhi, but at least you can go to a regional bench of the Supreme Court in Chennai. If you are from Arunachal, if you are from Assam, if you are from Manipur, Mizoram, Nagaland, if you cannot travel to Delhi, but at least you can travel to Calcutta, or you can travel to Guwahati. Let's have a regional bench in Guwahati, which is accessible to the entire Northeast. Have these regional benches, because the Supreme Court can sit in Delhi or in such other place or places as the Chief Justice of India, where time to time will appoint. Let's have more judges. We can have 30 judges in the Supreme Court in Delhi. We can have 10 judges in these regional benches. What's the harm? Let's make justice accessible to every single Indian, because our constitution starts with we the people of India. But the Supreme Court has rejected this. Despite the fact that Law Minister was in favor, Parliamentary Committee on Law and Justice was in favor, the Bar Council of India was in favor, the state governments were in favor, but the Supreme Court rejected this proposal, saying, no, we cannot have regional benches. Why? Two reasons were given. Which were these two reasons? Number one, it will affect the status of the Supreme Court as a national institution. Number two, these regional benches can come under the influence of local politics. The Supreme Court was told, since Article 130 provides that there can be a Supreme Court in Delhi and it can sit at any other place or places, can we have regional benches of the Supreme Court? Why should all cases come to Delhi? We can have a regional bench in southern India, eastern India, western India, northern India, or maybe in central India. Let's have these regional benches. Let's appoint judges to these regional benches so that these regional benches can also take up some load from the Supreme Court. Supreme Court said, no, we cannot do that because it will affect the status of Supreme Court as a national institution. As a national institution, we have to keep a check on ourselves. We may not be able to keep a check on the regional benches. It will affect our status as a national institution. That is why we will not agree. And what is this affecting the status of a national institution, I am unable to understand. If your court cannot cater to the justice of the massive majority of our population, then you are not a national institution in the first place. But be that as it may, the second argument may appear justified, that these regional benches will come under the influence of the local politics. So if there is a regional bench in Chennai, it will come under the influence of the DMK political party in Tamil Nadu, which is in power in Tamil Nadu. That is why we should not have regional benches. Appears a logical argument, but it is not a logical argument. Because in every state there is a high court. Then by your logic, every high court also comes under the influence of the local politics of that state. Then by your same logic, all the high courts should be dissolved, then we can only have the Supreme Court in Delhi. So your logic is illogical. And at the same time, there is always a provision. What is the provision? Transfer a case. What is transfer a case? For example, J. Jayalalitha. She was accused of possessing money, value of money, which was disproportionate to her known sources of income. So if this is her known source of income, she is the chief minister, she is a legislator, what is the amount of money that she could be holding? And based on this, what is the exact property that she is holding? Massive property. So this is disproportionate. From this small money, you cannot have these many properties. There was an allegation against her, matter went to the court, and now it is the Tamil Nadu High Court. It's the Madras High Court which is hearing this matter. But then there was an allegation that Madras High Court and the chief minister, the ruling party is AIADMK of Ms. J. Jayalalitha. They are imposing pressures on the Madras High Court. The Supreme Court said this case is transferred from Madras High Court to Karnataka High Court. Same happened in Gujarat. When there was an allegation that there is a pressure on the witnesses, there is a pressure on the investigation agency, maybe justice will not be done in Gujarat. The case was shifted from Gujarat to Maharashtra to the neighboring state. So whenever there is an allegation that a regional bench is coming under the influence of the local politics, there will always be a provision that that case will be shifted, transferred from one regional bench to another regional bench or to the Supreme Court in Delhi. But that won't happen every time. That would happen in the rarest of the rare cases. For the remaining cases, why can't we have Supreme Court in Delhi and the regional benches in 4 different regions of this country or 5 different regions in this country? So it is time to reconsider regional benches. There was another solution prescribed by former Chief Justice of India, Justice Balakrishnan. KG Balakrishnan. What did he say? He said it is time to split Supreme Court. Split Supreme Court in the sense, this is Supreme Court, split it into Cassation Court, and Constitutional Court. Why? Look at Supreme Court in Delhi. Look at the kinds of cases that go to Supreme Court. There is a case which says Yo-Yo Honey Singh's songs should be banned. Matter goes to the Supreme Court. An important constitutional case. Who is the real Shiv Sena? That is also heard in the court. Another matter. Arnab Goswami is arrested. He goes to the Supreme Court, give me bail. Manish Sisodia is arrested. He goes to the Supreme Court, give me bail. Supreme Court is today like an organization which hears all types of cases. Matrimonial disputes, divorce cases, civil cases, criminal cases, constitutional cases, election disputes, public interest litigation, bail cases, every kind of cases land at the door of the Supreme Court. When important cases, and thereby what happens? The important cases are kept on the back burner. Manish Sisodia approached the court, his case was heard. But he was told, you approach the Delhi High Court. Arnab Goswami approached, his case was heard. Arnab Goswami was released on bail. And when on a daily basis, Supreme Court is hearing these matters, which ideally should have been heard by the High Court, which ideally should have ended in the high courts. When Supreme Court is hearing all types of cases, even trivial cases, then they don't have the time for important cases. Important case such as electoral bond. Whether electoral bond is constitutional or not, we don't know, because the case is still pending since 2017. Whether Article 370 was rightly or wrongly diluted, the case is before the court, it's not being heard. Whether Citizenship Amendment Act is right or wrong, the matter is before the court, we don't know. Demonetization happened in 2016, and this demonetization judgment came this year. So basically, the Supreme Court is taking a lot of time to decide on important matters, but they are not at fault. It's because they are overburdened with a lot of cases. If you're overburdened with a lot of cases, we have a solution, my lord. And what is the solution? Let's split Supreme Court. How? Into Cassation Court and Constitutional Court. Let this court in Delhi, the Supreme Court in Delhi, act as a constitutional court only, which means these trivial bail applications, matrimonial disputes, civil disputes, contract cases, they will not go to the Supreme Court. Done and dusted. Supreme Court cannot hear these cases in Delhi. What Supreme Court will hear? Fundamental rights related cases. What Supreme Court will hear? Constitutional cases. What Supreme Court should hear? Federal cases involving disputes between the center and the states, involving disputes that the states will have with each other. Only those disputes should be heard by this constitutional court in Delhi. Then all other cases, who will hear these cases? Cassation Court. Where will this Cassation Court be? It will be in Northern, Eastern, Western, Southern, and Central India. Have Cassation Court, which will basically be the court of appeal. What is this court of appeal? There is district court which says you hang by your neck till death. You approach the high court. High court says you hang by your neck till death. Then what do? You go to the Supreme Court in Delhi. Instead of going to Supreme Court, go to a Cassation Court in your South India or North India or Central India. It is different from a regional bench, because regional bench can hear all kinds of cases, constitutional cases, fundamental rights related cases. Every case which is heard by the Supreme Court in Delhi can be heard by these regional benches. So there is no difference between a bench of the Supreme Court in Delhi and the bench of the Supreme Court in Chennai. No difference whatsoever. But there is a difference. If we split Supreme Court into Cassation courts, that means these courts will be the court of appeal. That means from district court, the court case will go to the high court, then will go to the Cassation Court in your region, which is South India. That means all these cases where you have to file an appeal, where you would normally go to the Supreme Court in Delhi, you can go to this Cassation Court. But this Cassation Court cannot hear constitutional cases. This Cassation Court cannot hear federal cases. This Cassation Court will not hear cases involving interpretation of the Constitution. Such cases can only be filed in a constitutional court in Delhi. What will happen because of this? Supreme Court in Delhi will have enough time, solid time, to look at important constitutional cases, so that they can be removed from these useless or petty cases such as the matrimonial disputes, such as the bail applications, such as other civil and criminal cases. And for this, we need to amend the Constitution, because any change in the structure of the Supreme Court or High Courts, for that we need to amend the Constitution. And to amend the Constitution, we need ratification by more than half of the states as well, just like we did in case of NJAC. That is what you need to know from Article 130. Any questions? So there are millions of cases pending. Also, many cases are heard and postponed. How can we tackle this? We will discuss this towards the end. So that's an important question, relevant for your mains. We will discuss that. If unfavorable decisions given by the regional benches, is there still a door open to approach the High Court? When you say, is there a door open to the High Court? Right now, regional benches have not been constituted. Right now, there is no Cassation Court. no split of the Supreme Court. The same structure that is there, it continues. This is the reform that we are suggesting. And the reform is, if the regional bench has given the order, it is final. Just like the order given by the Supreme Court is final. So tomorrow you can say, what if Supreme Court also does not give the final good favorable judgment? Then there should be a Supreme Court above the Supreme Court, Supreme Court. Then what if that court also does not give the favorable order? Then Supreme Court. Then it will lead to Supreme, and we will reach to Supreme God and ultimately say whatever God decides is the correct decision. Then there should be a God above the God as well. So this hierarchy does not end. Okay. Now we see Supreme Court and High Courts. They act as court of record. District courts are not the courts of record. What does that mean? For a judicial body to be classified as the court of record, it must meet two conditions. Condition number one, all the judgments, all the proceedings, whatever is decided, that should be kept on record. That means that should be recorded, that should be saved, that should be typed, and that should be used for posterity forever and ever and ever. In the sense, if you are watching on YouTube, for example, the live proceedings of the Supreme Court, all the constitution benches, whenever they sit, whenever the Supreme Court hears a constitutional case, which means 5 judges or more, all the proceedings of the Supreme Court are live streamed on their YouTube channel, the Supreme Court of India YouTube channel. And you would see that there are, so don't go by the impression of the courts by looking at the Bollywood movies. They may not give you the real interpretation or the real flavor of what exactly happens in the court. But take a look at some of the Supreme Court live proceedings videos on YouTube channel, and you will see that here the judges are sitting, and just below the judges, there are individuals on typewriters, on computers. What do? All the arguments made by the advocates, all the questions asked by the judiciary, they are all recorded. They're all typed and they are saved. So that means every proceeding goes on record. Just like Parliament, whatever you say inside the Parliament goes on record, is recorded, so that even after 20 years, even now you can go and listen to what the Constituent Assembly debated, what the Parliament of India did in 1952, what the Parliament of India debated in 1971, everything is on record. Similarly, district courts, high courts, Supreme Court, they fulfill this condition number one, that all the proceedings, all the judgments, it goes on record. Clear? And condition number two, this judicial body should have the power to punish people for contempt. And what is this contempt of court? We have discussed in Article 19. Contempt is civil contempt, criminal contempt. But high courts and district courts, but high courts and Supreme Courts, these are the two institutions which can punish people for contempt. If you commit contempt of high court will punish you. If you commit contempt of the Supreme Court will punish you. That means high courts and Supreme Courts, they follow both the conditions. They satisfy both the conditions of being the court of record, which means all their orders, all their judgments, all their proceedings are recorded. Number one. Number two, they have the power to punish people for contempt. Clear? But when it comes to a district court, district courts fulfill criteria A, but does not fulfill criteria B. That means district courts cannot punish people for its contempt. Does that mean you can commit contempt of the district court? No. If you commit contempt of the district court, the concerned high court shall punish for contempt. For example, district court tells you that next hearing you have to appear before us. What if you're not appearing before the district court? You're committing contempt of the district court because you're willfully, deliberately disobeying the court order. But district court cannot punish you for contempt. What district court will do, will ask the concerned high court. High court, he has committed contempt of me. Please help me. High court will say, don't worry, bacha, you are under my supervision. Come here. You are punished for contempt. So Supreme Court and high courts, they fulfill both the criteria of a court of record, but district court fulfills criteria one only because district courts does not have the power to punish people for its contempt. But that doesn't mean you can commit contempt of the district court. If you commit contempt of the district court, the concerned high court will punish you for contempt. Clear? Sir, is Collegium working or NJAC is working? My dear, yesterday I banged my head in explaining why NJAC was declared unconstitutional by the judiciary on the grounds of violating independence of judiciary, on the grounds of violating basic structure. And today you are repeating the same question. Is NJAC working or Collegium working? It's Collegium, my dear. And even if you don't know, but just look at this empirical data. Why are we discussing that Collegium recommended names of Saurabh Kirpal, Victoria Gowri, R. John Sethian, and some of these recommendations accepted, not accepted? Have we discussed NJAC anywhere then? No, that means Collegium system works. Okay? Pujaba, what's your question? Now let's look at some of the powers of the Supreme Court. And this is what we call the jurisdiction of the Supreme Court. To which areas does the power of the Supreme Court extend? First jurisdiction is original jurisdiction. And to understand original jurisdiction, we also need to understand original and exclusive jurisdiction. Clear? What is original jurisdiction? Normally, you go to a district court, not happy with this verdict, you go to the high court. Not happy with this verdict, you go to the Supreme Court. Clear? But can you directly approach the Supreme Court? No. You have to go through district court, then high court, then Supreme Court. That means this particular case, which traveled from district court, then to high court, then Supreme Court. Supreme Court does not have original jurisdiction on this case, which means this case is reaching Supreme Court, but through appeals. When you're filing an appeal against the district court, when you're filing appeal against the high court, when you are reaching the Supreme Court. Are there cases which you can directly file in the Supreme Court? All those cases which you can directly file in the Supreme Court, we say Supreme Court has original jurisdiction on these cases. Clear? But then there are some cases which can be directly filed in the Supreme Court, yes. But at the same time, these cases can be filed only in Supreme Court. Such cases are known as Supreme Court having exclusive jurisdiction on such cases. So what is a case? This case can be, you cannot directly approach the Supreme Court. Why? Because this case, you have to first go to the district court, then to the high court, then you can go to the Supreme Court. So on these cases, Supreme Court does not have original jurisdiction. On these cases, Supreme Court has appellate jurisdiction. Appellate jurisdiction means Supreme Court can hear appeals. When you're not satisfied with the verdict given by the High Court, you appeal before the Supreme Court. So Supreme Court has a jurisdiction to hear this case, but not original jurisdiction, appellate jurisdiction, because you're filing an appeal against the order of a district court, against the order of a High Court. But if there is a case which you can directly file in the Supreme Court, we say Supreme Court has original jurisdiction on these cases. These cases you can directly file before us. But if there are some cases which can be only filed in the Supreme Court, we say such cases are known as exclusive jurisdiction. Can you tell me some examples? For example, fundamental rights. On fundamental rights, what sort of jurisdiction does the Supreme Court has? Supreme Court has original jurisdiction on fundamental rights cases. Why original jurisdiction? Because you can directly approach the Supreme Court. Not through an appeal, but you can directly approach the Supreme Court. Supreme Court has the original jurisdiction on fundamental rights cases. But now you tell me, does Supreme Court have exclusive jurisdiction over fundamental rights cases? No. Why? Because you can approach High Court also under Article 226 if your fundamental rights have been violated. So yes, fundamental rights cases are under the original jurisdiction of the Supreme Court, which means you can directly approach the Supreme Court when your fundamental rights are violated under Article 32. But you can also approach the High Court under Article 226. So Supreme Court has original, but does not have exclusive jurisdiction over fundamental rights cases. But then can you give me an example of where is the exclusive jurisdiction of the Supreme Court? Federal cases. A dispute between Karnataka and Maharashtra cannot be filed in any court, only in the Supreme Court. A dispute between Center and Kerala cannot be filed in any other court except in the Supreme Court. A dispute which arises out of the election of the president or the vice president, whenever there is a doubt on the election of the president or the vice president, such a case can be filed only and only in the Supreme Court, no other case. That means on federal cases, on elections related to president and the vice president, Supreme Court has original and exclusive jurisdiction. That means such cases can be directly filed in the Supreme Court, original. Such cases can be only filed in the Supreme Court, exclusive. That is what we call original jurisdiction. Supreme Court has original as well as exclusive jurisdiction in any dispute. Which dispute? Between the government of India and one or more states. Between the government of India and any state on one side and states on the other side. Between two or more states. On all these cases, because these cases are federal cases. On all these federal cases, Supreme Court has the original exclusive jurisdiction, which means only and only Supreme Court has the power to adjudicate these federal cases, to decide on these federal cases. Done? A court has original jurisdiction when it has the authority to hear and determine a case in the first instance. What is that first instance? Normally you go to the district court, then High Court, then Supreme Court. So this is the third instance. But those cases which you can directly file in the Supreme Court, that means in the first instance itself, that is original jurisdiction. And it has exclusive jurisdiction when it has the authority to hear and determine a case which no other court can hear or determine. That's the difference between exclusive and original jurisdiction. But there are some exceptions as well. There are some areas where the Supreme Court does not have the jurisdiction, does not have the original jurisdiction, does not have the exclusive jurisdiction. Which are these cases? A treaty of pre-constitutional era. 1950 Constitution was enacted. Prior to 1950, there may have been a treaty. There may have been an agreement. What is agreement? Let's say there was an instrument of accession signed by all the princely states when they joined the Union of India. When Baroda, when Hyderabad, when Junagadh, when others, when Jammu and Kashmir acceded to the Union of India, all these princely states, they signed instrument of accession. So this instrument of accession is a pre-constitutional treaty which came into existence prior to the commencement of the Constitution. Can tomorrow somebody file a case in the court and say, let's revisit the instrument of accession signed by Maharaja Hari Singh and Lord Mountbatten? No, the Supreme Court does not have the jurisdiction to hear this case because this case involves pre-constitutional treaty, pre-constitutional agreement. Number one. Number two, Article 262. And what is Article 262? Now there's a pin drop silence in the comment section. Nobody replying. What is Article 262? Somebody says river. Somebody says water. Should also say jal. Tribunal. Financial. Don't know. Very good. Center-state relationship. Parliament. My God. Matters. What happened, my dear? Interstate river water disputes. Article 262. Parliament may adjudicate by law interstate river water disputes and even exclude the jurisdiction of the Supreme Court. Supreme Court does not have original jurisdiction to hear an interstate river water dispute because primarily it's a political dispute. It's a federal dispute. Matters related to the Finance Commission. Now, what is a Finance Commission? We'll discuss that in economics, but very briefly here. Under Article 280, every 5 years, the President sets up a Finance Commission. What is the job of this Finance Commission? Various responsibilities. One big responsibility is that there are some taxes which are levied by the center, which are collected by the center, but whatever revenues generated from these taxes are to be shared with the states. For example, income tax imposed by the center, collected by the center, but is to be distributed with the states. Corporate tax imposed by the center, collected by the center, but whatever proceeds are generated, we have to distribute it with the states. We have to share it with the states. On what basis? What is the formula? What is the percentage? That is decided by the Finance Commission. And if the Finance Commission says 41% of this tax should be shared with the states, or 42% of this tax should be shared with the states, you cannot approach the court and ask the courts that make 42% into 82%, or make 42% as 10%. No, that you can't do. Because in these Finance Commission matters, the Supreme Court does not have the original jurisdiction. These are some of the examples. One more example, Article 290, although it is not relevant now, but it was relevant then. Relevant at the time of the commencement of the Constitution. Prior to the commencement of the Constitution, there were various offices. Offices during the colonial government, during the colonial period. Now, if we don't need these offices, we don't need Governor General, we don't need those officers who are part of the Governor General. What should we do with them? We have to remove them from the service. When we have to remove them from the service, we have to give them some severance package. For example, when employees are laid off in organizations, they give them severance package as well. We will give you 2 months salary, we will give you 1 month salary, we'll give you 15 days salary, so on and so forth. So when these officers are to be removed, when these employees are to be removed, what sort of salary, what sort of severance package is given by the central government? You cannot challenge that in the court under Article 290. So there are some matters where the Supreme Court does not have the original exclusive jurisdiction. Which are these matters? And you will realize that all these matters are purely political matters. And all these political matters are left to the political class. Let the political class deal with these matters. The courts will stay away from it. That means an agreement or a treaty of a pre-constitutional era, the Supreme Court does not have the original jurisdiction. An interstate river water dispute, Supreme Court does not have the original jurisdiction. Matters related to Finance Commission, the Supreme Court does not have the original jurisdiction. But sir, if Supreme Court does not have the original jurisdiction, then why is Supreme Court still hearing interstate river water disputes? And I've told you the reason. The reasons are two. One, the court has said that this interstate river water dispute also includes water sharing. and on water, livelihood of the farmers is dependent. Right to livelihood is a fundamental right. So we will hear this matter. And we are not practicing original jurisdiction or exclusive jurisdiction. We are practicing appellate jurisdiction. That means when the tribunal has given an award, you can approach us against the award given by the tribunal. So we are not hearing interstate river water dispute in the first instance as the original jurisdiction or as the exclusive jurisdiction. We are hearing it through an appeal. We are practicing appellate jurisdiction because in the first instance, this matter is decided and heard by a tribunal. Clear? That is what we call original jurisdiction. Then we have something called writ jurisdiction. And writ jurisdiction we have discussed under Article 32 of the Constitution. What are the 5 writs which can be issued by the Supreme Court, which will protect the fundamental rights of the people of India? Habeas corpus, mandamus, prohibition, certiorari, quo warranto. Through these 5 writs, the fundamental rights are protected, safeguarded. And Supreme Court is the protector of your fundamental rights. And the Supreme Court is the guardian of the Constitution. Protector of fundamental rights. So on fundamental rights related cases, Supreme Court has the jurisdiction. What is that jurisdiction? Writ jurisdiction. What is writ jurisdiction? It can issue writs, it can issue directives. And through these directives, it can protect your fundamental rights. That is what we call writ jurisdiction of the Supreme Court. Any questions? Yes, no, maybe. High courts can also issue writs, yes. Okay, so let's take a break. Let's meet at 7:45 and we will discuss appellate jurisdiction, we will discuss advisory jurisdiction, revisory jurisdiction, curative petitions, and then we will jump to public interest litigation. So see you on the other side of the break. Shall we resume? Even if you say no, even then we have to. Let's look at appellate jurisdiction. What is appellate jurisdiction? Some cases reaching the court, the Supreme Court, but not directly, not in the first instance, but through an appeal. When you file an appeal against the order of the High Court, that is what we call the appellate jurisdiction. But what are these cases which reach the Supreme Court? This case can either be a civil case or a criminal case or a constitutional case. For example, a constitutional matter. Now, what is a constitutional matter? For example, Hadia. Her name was previously Akhila, a Hindu. She converted to Islam, took the name Hadia, married a Muslim, Shafin Jahan, and ultimately they were living happily. But the father raised a complaint. Father of the girl raised a complaint that this is basically the conspiracy of the ISIS, the Islamic State. My daughter has been forcefully converted into Islam and then she married a Muslim. So please investigate this matter. Matter went to the Kerala High Court. Although this was a marriage material or a matter related to marriage, Kerala High Court annulled the marriage, saying this marriage is not valid. When this marriage was annulled, Shafin Jahan, the husband of Hadia, approached the Supreme Court. How? Because he said this matter is basically a constitutional matter. What sort of constitutional matter? Right to marry is a fundamental right under Article 21 of the Constitution. But when the High Court rejected this marriage, annulled this marriage, High Court granted a certificate. And with this certificate, it was mentioned that this case involves the interpretation of a constitution, whether right to marry is a fundamental right or not. So we will ask the Supreme Court, you can hear this matter. You can have this appellate jurisdiction on this matter. Without this certificate, you cannot approach the Supreme Court. Now, sir, what if the certificate is not issued? I'll tell you the recourse there as well, solution, remedy there as well. But here, look at what this matter is. The matter is related to marriage, but the petitioner is raising a constitutional question that how can the High Court decide and annul this marriage if the marriage is of two consenting adults above the age of 18? It violates my fundamental right to dignity. It violates my fundamental right, which I'm saying right to marry is also a fundamental right. High Court said, since you are raising a constitutional question, who is the final interpreter of the Constitution? Supreme Court. We will issue you a certificate. Take the certificate, go to the Supreme Court. Supreme Court will look at the certificate because the High Court is saying that this case involves interpretation of the Constitution, and we will then hear this case. It's a constitutional case. But without the certificate, you cannot approach the court. Similarly, this matter can be a civil matter involving a dispute between you and me on land, or if I have violated a contract, or if you were owing me money, but you are not repaying that amount. It's a civil dispute between you and me. If this civil dispute is heard by the High Court, but you are not satisfied with the High Court order, what you will do, you will ask the High Court, please give me a certificate. What should be mentioned in the certificate? That this case is fit to be heard by the Supreme Court. Take that certificate and then go to the Supreme Court. Supreme Court will read the certificate. Since the High Court has certified that this case is fit to be heard by the Supreme Court, we will hear your case. Then it can be a criminal matter. And what is a criminal matter? District Court has sentenced you to death. High Court also has sentenced you to death. This matter goes to the Supreme Court as a matter of right. It's your right to approach the Supreme Court. Supreme Court has to hear this case because it involves the matter related to death. But what if district court sentence you to a term of 10 or more years? High Court also sentences you to 10 or more years? Then High Court should give the certificate that this case is fit to be heard by the Supreme Court. Only by this certificate can you file an appeal against the order of the High Court in the Supreme Court. Without the certificate, you cannot. Long story short, if you want to become a lawyer, then there are lots of nitty-gritties in these cases, how you can approach the Supreme Court. But you're not here to become the lawyer. You're here to clear the civil services examination. For that, just understand the concept. What is the concept? Appellate jurisdiction. Appellate jurisdiction of Supreme Court. That means Supreme Court can hear appeals. Appeals against what? Appeals against the order of the High Court. What are these cases? Case can be constitutional, case can be civil, case can be criminal. In a constitutional case, if the High Court issues a certificate saying this matter involves the interpretation of the Constitution, take that certificate, go to the Supreme Court will hear your appeal. If it's a civil matter, unless and until that certificate is issued by the High Court, which says that this is a fit case to be heard by the Supreme Court, take the certificate, approach the Supreme Court will hear an appeal against the order of the High Court in the civil matter. If it's a criminal case where you have been sentenced to death, it's your right to approach the Supreme Court. It's a matter of your right. You don't need a certificate from the High Court. You can approach the Supreme Court against the order of the High Court. So High Court's decision will be appealed before the Supreme Court. Supreme Court will have the appellate jurisdiction in this criminal matter. But if the High Court sentences you to 10 or more years in jail, not death, 10 or more years in jail, then without the certificate issued by the High Court, you cannot approach the Supreme Court. Take the certificate, it should be mentioned that this is a fit case to be heard by the Supreme Court. If you have the certificate given by the High Court, approach the Supreme Court will hear an appeal against the order of the High Court. But what if the certificate is not issued? What if the High Court refuses to give you the certificate, and without the certificate you cannot approach the Supreme Court? There is a provision known as special leave petition. Special leave petition under Article 136 of the Constitution. What is Article 136 of the Constitution? Even without a certificate, you can approach the Supreme Court, file a petition under Article 136 known as special leave petition. And if Supreme Court is satisfied, Supreme Court will hear your matter and will then decide whether you are guilty or not. So this is basically the discretion of the Supreme Court. This cannot be a matter of right. Or special leave petition can be, High Court is already hearing a particular case, but you're not satisfied with the way the High Court is proceeding with that case. You can file a special leave petition in the Supreme Court under Article 136. If the Supreme Court is okay with your arguments, accepts your arguments, is convinced by your arguments, that matter can be left and you can file this case in the Supreme Court. That means now Supreme Court will start hearing this matter. But this special leave petition cannot be filed against the order of a military tribunal. What does that mean? There is an army man who is accused of corruption, or who is accused of misbehavior, or who is accused of adultery. Then this army personnel can also be dismissed from the service. For that, there are no regular courts for army. They will have to approach the military tribunal. Military tribunal, which consists of the members of the army, they will decide whether you are guilty or not. And they will decide whether you are to be dismissed from the service or not. And once the military tribunal has given the order, If the military tribunal allows you to approach the Supreme Court, only then you can approach the Supreme Court. If the military tribunal does not, that means the case ends at the military tribunal. You cannot file a special leave petition against the order of the military tribunal under Article 136 of the Constitution. Long story short, certificate is important. This certificate is to be issued by the High Court. If High Court does not issue the certificate, that basically means the case ends at the High Court level, the case is dead and the final judgment is given. But if this certificate is given, then you can approach the Supreme Court, and Supreme Court will hear appeals against the order, against the verdict, against the judgment of the High Court. But what if you think that the certificate was not given because there is bias, because there is violation of principles of natural justice, or whatever your allegation is? You can approach the Supreme Court, file a special leave petition under Article 136, and then convince the court with your arguments that the certificate was not issued because principles of natural justice have been violated, because the judges are biased against me, because of these reasons. And if the judiciary is convinced, that means it's the discretion of the Supreme Court. It's the discretion of the Supreme Court whether to admit or refuse special leave petition. It's not your right. And if the Supreme Court accepts your special leave petition, then the Supreme Court will hear the appeals against the order of the High Court. But you cannot file a special leave petition against the order of a military tribunal. That's Article 136 of the Constitution. But then something else. Advisory jurisdiction. And what is advisory jurisdiction? Something which is not there even for the US president. That is for the Indian president under Article 143 of the Constitution. What happens? Supreme Court is the advisor of the President of India. Supreme Court is the advisor of the President of India. Supreme Court can refer any matter to the Supreme Court, asking the views of the Supreme Court on that matter. But this matter on which the Supreme Court can give the advice to the President, this matter can be categorized into two broad categories. Either this is a pre-constitutional matter, or this is a post-constitutional matter. If this matter, President is referring to the Supreme Court, asking the advice of the Supreme Court on this matter, if it's a pre-constitutional matter, it is binding on the Supreme Court to give advice. If it's a post-constitutional matter, not binding on the Supreme Court to give advice. That means a pre-constitutional matter, Supreme Court does not have original jurisdiction. But what Supreme Court can have? Advisory jurisdiction, which means Supreme Court can be asked to give an advice on a pre-constitutional matter, something which has existed prior to the commencement of the Constitution. For example, prior to the commencement of the Constitution, a law was passed called Muslim Personal Law Shariat Application Act 1937. Basically, it is this Muslim personal law which deals with the personal laws related to the Muslims, related to marriage, related to divorce, related to inheritance, related to adoption. On this Muslim Personal Law 1937, can Supreme Court be asked to give an advice whether it violates fundamental rights or not, whether it is compatible with the ideas of justice mentioned in the preamble of the Constitution? If the President wants, it can send she can send the matter to the Supreme Court, asking the views, asking the advice of the Supreme Court on this matter. And it is binding on the Supreme Court to give an advice. But if it's a post-constitutional matter, something which has happened after the Constitution was enacted in 1950, if this matter is referred to the Supreme Court by the President asking for the advice, it is not binding on the Supreme Court to give an advice. But normally, Supreme Court gives the advice. For example, we saw in 1998, third judge's case. What was that? That was basically a presidential reference. What is that presidential reference? Because this matter, appointment of judges, it was referred to the Supreme Court by the president, asking the advice of the Supreme Court on this matter as to how can we appoint the judges. It's a post-constitutional matter. Although it's not binding on the Supreme Court to give its advice, but nevertheless, Supreme Court gave the advice. That is the advisory jurisdiction. But Supreme Court has said in few cases, listen to me carefully, if on a pre-constitutional matter, it is binding on the Supreme Court to give advice to the president. If this matter has been referred to the Supreme Court to give an advice, if the Supreme Court in its reply says on this matter we have no advice to give, this statement that on this matter we have no advice to give can be treated as an advice. This is our advice to the president. Then on this matter we have no advice to give. That means the satisfaction is taken, which means Article 143 has been satisfied. But at the same time, is this advice binding on the president? Whatever advice is given by the Supreme Court, now this advice, can it become binding on the president? The name suggests this is advisory jurisdiction. Supreme Court is there only to give an advice. So if the question comes in the prelims examination under advisory jurisdiction, is the advice of the Supreme Court binding on the government? No, it's only an advice. But technically, practically, it becomes binding. Binding in the sense, 122 2G licenses were cancelled by the Supreme Court. 2013, 122 2G licenses were cancelled by the Supreme Court. Then the president referred this matter to the Supreme Court, asking the views of the Supreme Court on this matter. My lord, please now tell us, what is your advice on this? How should we give spectrum? How should we allow private players to participate in this program so that we can give them spectrum licenses? Spectrum is 2G wave, 3G waves, 4G waves, 5G waves. This spectrum is to be allocated to private players. Supreme Court gave an advice. Supreme Court said whenever you have to allocate spectrum to private players, go through auction. You should auction it. When you auction it, that means you give the spectrum to the highest bidder. Reliance, Tata's, Airtel, Vodafone Idea, they will all participate in this bidding, and ultimately whoever pitches the best price gives spectrum to that highest bidder. That is how we can generate more revenue. That is our advice. What if tomorrow the government decides not to follow auction, but decides to allocate spectrum on first come first serve basis? That means whoever comes first for the spectrum, we will assign spectrum to that company. We will not go through the auction route. Then the court will come into the picture and said, no, this is unconstitutional. You can't do that. So technically it becomes binding on the government. But in theory, if this is a question asked in your prelims examination, this advice given by the Supreme Court is not binding on the President of India. Long story short, what is the advisory jurisdiction of the Supreme Court? Supreme Court can be referred by the President of India any matter, asking the views of the Supreme Court, asking the advice of the Supreme Court on this matter. But this matter can be a pre-constitutional matter on which it is binding on the Supreme Court to give an advice. If it's a post-constitutional matter, it is not binding on the Supreme Court to give the advice. But since it is advisory jurisdiction, this is only an advice to the president, this is only an advice to the government, it is not binding on the government. That is advisory jurisdiction. Okay. Now let's look at revisory jurisdiction, where we will discuss what is review and what is curative petition. All the judgments of the court, of the Supreme Court, they are binding because judgments given by the court, Article 141 says it is the law of the land and you have to abide by the law of the land. So it becomes binding on anybody and everybody. But the Supreme Court has the power, has the jurisdiction to revise its own judgment. Matter has been decided by the Supreme Court. But can Supreme Court now revisit this judgment? revise its judgment? Yes. And for that, you have to file a petition known as review petition. Even if this review petition is dismissed, can you file another petition? Yes. Can you file another review petition? Yes. And what is that another review petition? That is known as curative petition. And once curative petition is also dismissed, then the case ends, the finality of the judgment becomes clear. Which means Supreme Court has the power in the interest of the justice. Because when Supreme Court gives a verdict, somebody may point out that there is an error in your judgment. Please revisit your judgment. You can file a review petition. Even if you're not satisfied with the verdict in the review petition, you can file another review petition, and that is known as curative petition. And once curative petition is also dismissed, the case is over. Now you cannot file this case in any other court of this country. The only thing that you can file a mercy petition before the President of India. Clear? But what is a revisory or review petition? Sabrimala, for example, a 5-judge bench of the Supreme Court in 2018 said, women of all age groups may pray at Sabrimala. That means this restriction on the women in the age group of 10 to 50, that you cannot enter the sanctum sanctorum of the Sabrimala temple. These rules are unconstitutional. Women of all age groups, including 10 to 50, can pray at the Sabrimala temple. This was the judgment given by the Supreme Court. Can you file a review petition before the Supreme Court, asking the Supreme Court to review your petition, to revise your petition? Yes. But for that, 2 conditions need to be satisfied. Which are these 2 conditions? Number 1, new facts have emerged in the case. Number 2, an error has been pointed out. What does that mean? Let's say, for example, 2.77 acres of land at Ayodhya. There was a dispute as to who is the owner of this land. Matter went to the Supreme Court. First, it went to Allahabad High Court. Allahabad High Court said 3-way division. 1/3 of this land should be given to Nirmohi Akhara. 1/3 of this land should be given to Ram Lalla. 1/3 of this land should be given to Muslim Waqf Board. But petitioners were not satisfied with this division, this 1/3 division of this 2.77 acres of land. Matter went to the Supreme Court. An appeal was filed before the Supreme Court because the High Court issued a certificate. If you want, the petitioners, you can approach the Supreme Court. This case is fit to be heard by the Supreme Court. Although it was a civil matter. It was a title dispute. Who owns this land? That's the dispute all about. Matter went to the Supreme Court. Supreme Court said the entire 2.77 acres of land should be given to Lord Ram so that we can construct a mega Ram temple at Ayodhya. So the entire land was given to Lord Ram. But then in this case, Supreme Court invoked Article 142 of the Constitution. What is Article 142 of the Constitution? Supreme Court can give any order so as to give complete justice. And what is this complete justice? Supreme Court said in 1949, when the idols of Lord Ram were placed under the central dome of the Babri Masjid, basically you have violated the sanctity of a mosque. So this is a criminal act. That's what the Supreme Court said, not me. 5 judges of the Supreme Court, including Justice Ranjan Gogoi, that's what they've said. They've said that this was a criminal act. But then this 2.77 acres of land should be given to Lord Ram. And even the 1992 demolition of Babri Masjid, this was an act on secularism, against secularism. This demolition should not have taken place. But then when the entire dispute, listen to me carefully, when the entire dispute is on 2.77 acres of land, clear? Who is the owner of this land? Now the owner of this land is the Lord Ram. That means all the other petitioners, their claims have been rejected. Normally, in a cricket match, there is a winner, there is a loser. In this case also, there is a winner, Lord Ram, there are losers, Nirmohi Akhara and the Muslim Waqf Board, their claims have been rejected that you are not the owner of this land. Now, even then, to give complete justice, what Supreme Court said, 5 acres of land in Ayodhya at a prominent place should be given to Muslims. Why? Because they have lost their place of worship, they have lost their mosque. And to give complete justice to them, we need to provide 5 acres of land at a prominent place in Ayodhya for the Muslims, where if they want, they can set up a mosque, they can set up a hospital, whatever they want to do. So that is complete justice. Supreme Court can give any order so as to give complete justice. Although in this case, there is a winner or there is a loser. If Lord Ram has won, all others are losers. But even then, if the entire land belongs to Lord Ram, why are 5 acres of land given at a prominent location in Ayodhya to Muslims? Because Supreme Court said Muslims lost a place of worship and we will give them an alternate land, 5 acres, more than 2.77 acres. The dispute was on 2.77 acres. Supreme Court said no, give them 5 acres because they have lost the place of worship, so as to give complete justice. The Muslim Waqf Board filed a review petition challenging this verdict given by the Supreme Court. But to file this review petition, it had to convince the Supreme Court on 2 grounds. Ground number 1, that new facts have emerged in a case, which were not considered in the case previously. For example, if the Muslims would have said that in Ayodhya judgment, my lord, you said that mosque is not an essential religious practice. Or you said that we could not claim this land because for this particular period, we could not prove that we were in the possession of this land. Now we have got hold of documents. These documents clearly tell us that during this period, this land was under our control. We have the ownership of this land. So new fact has emerged. When new fact has emerged, the courts will consider, okay, now since the new facts have emerged in this case, we are going to review our judgment. Or the petitioner should say that there is an error in your judgment. What is the error? Let's say, for example, the court said in Ayodhya case, there is something called preponderance of probability. What is preponderance of probability? In a sense that circumstantial evidence is such that we can say that throughout the history, Hindus were continuously worshipping Lord Ram in that area. That means continuous possession of this area was under Hindus. During some time in the intermediate, the Muslims were not praying or offering namaz in the Babri Masjid. Then the probability is that Muslims were never truly in possession of this property. And Hindus were always in the possession of this land, which means who is the owner of this land? Lord Ram. If you can point out an error in this case, saying, sir, in a previous judgment, you have discarded this theory of probability. You have said on probability, we cannot give judgments. If you can point out this error in your judgment, then the courts can review its judgment. But if no new facts have emerged and the petitioners are unable to point out an error, this review petition will be rejected. When review petition is rejected, the case is over. Can you file another review petition? Yes. And what is that another review petition? That is known as curative petition. And what is this curative petition? The Supreme Court said, which is something unique to India, which was not originally part of our judicial system. In a landmark case, Hurra versus Hurra 2002, the Supreme Court said, finality of justice is important. But it cannot be at the cost of justice. Yes, there should come a time where the judgment should become final, because we can't keep the pot boiling. There should come a stage where the case ends. Put the lid on this case, the case is over. Finality of justice is important, but it cannot be at the cost of the justice. What if justice has been violated in a particular case? Even after your review petition is rejected, you can approach us again, and we will then decide whether we are going to hear this case again or not. And that another review petition is known as curative petition. But the success rate is very less than 1%. Curative petitions have been accepted by the Supreme Court, because to satisfy conditions which are given in Hurrah versus Hurrah judgment, on the basis of which your curative petition can be accepted, is very, very difficult. Difficult in the sense, number one, you have to convince the judges that principles of natural justice has been violated. That the judgment has adversely affected the petitioner. Number three, there was an element of bias in the judgment. Once the final order is given by the Supreme Court, then you can file a review petition. But who will hear this review petition? This review petition heard by same judges. That means the Ayodhya verdict, which was given by 5 judges, if you have to file a review petition against the Ayodhya verdict itself, the same 5 judges will hear your review petition. Why? Because these judges have given the verdict. Now you are saying new facts have emerged. They already know details about this case. Now if you can say new facts have emerged, they will know, okay, this indeed is a new fact. Or if you can point out an error in the judgment, they would then be convinced that yes, in our judgment we have given an error. There is a mistake in our judgment. So the same 5 judges who heard the Ayodhya case will hear the review petition as well. If 1 judge or 2 judges, they have retired, then 2 other judges will hear the case apart from the 3 other judges. But the same judges who heard your case will hear your review petition. And if your review petition is dismissed, then you can file another review petition known as curative petition. But for the Supreme Court to hear this curative petition, it has to be convinced on various grounds that the principles of natural justice were violated. Why? Because this judge who gave this verdict against me, I had filed a case against this individual. On this case, the High Court said I am guilty. Supreme Court said I am guilty. This review petition said I am guilty. But do you know who this individual is? This individual is the son of this judge, and we were not aware of this. Principles of natural justice has been violated because you cannot be the judge in your own case because you are party to this individual. And in fact, there is an element of bias because of this. And because of this, this judgment has adversely affected me. What can adversely affect you? Death. That is why most of the death sentence cases, they end up in the curative petition. Curative petition is filed against them. But even if this curative petition is dismissed, the case is over, the justice becomes final. That is what we call revisory jurisdiction, which means the power of the Supreme Court to revise its own judgment. And for that, you have to file a review petition. If this review petition is dismissed, you can file another review petition. And that another review petition is known as curative petition. This curative petition was not originally part of the Constitution or was not present in India. It was innovated by the Supreme Court in Hurrah versus Hurrah case, Ashok Kumar Hurrah, Rupa Kumar Hurrah case in 2002, where Supreme Court said finality of justice is important, but it cannot be at the cost of the justice. And we will hear the curative petition. Once the curative petition is dismissed, then the case is over. And that completes our discussion on the jurisdiction of the Supreme Court. Any questions? The curative petition will be heard by the same judges who heard this matter, as well as 2 senior judges of the Supreme Court. In Ayodhya case, curative petition was not filed. Any questions? Let me know fast. Then we have to discuss something very important, very interesting. Is there any limit to file review petition? Yes. Review petition should be filed within 30 days of judgment. But glad you asked this question, and I remembered something else as well. Within 30 days of your judgment, a review petition is filed. Then curative petition is to be filed. Since curative petition is also a review petition of your review petition, that means even that curative petition should be filed within 30 days of the dismissal of your review petition. But sometimes this 30-day limit, even if you are filing review petition after 30 days, you have to convince the court what caused the delay, why you were not able to file this review petition within 30 days. And if you can convince the court will accept your review petition, the court will accept your curative petition. Is there any curative petition pending right now in India? Yes. Bhopal gas tragedy. When Bhopal gas tragedy took place, the Union Carbide was imposed millions of dollars of fine. Millions of dollars of fine was imposed, and ultimately the court said, yes, this is a fair judgment in this case. Now, after more than 30 years, curative petition has been filed by the central government. And the central government wants that this compensation which Union Carbide had to provide to those who got affected because of that gas leak in Bhopal, that compensation should be enhanced. The Supreme Court asked, how can you file this petition after so many years? After so many decades, you're approaching us to file this curative petition. The government could convince the court that since new facts have emerged in this case, since in this case we can say that this compensation is not fair, since in this case we can say that it has adversely affected the people who have got affected by this gas leak, that is why you have to hear this curative petition. And now this curative petition is being heard by the Supreme Court. And once this curative petition is decided, then we will have to wait and see what was the decision taken by the Supreme Court. But in all likelihood, I don't see Supreme Court enhancing the compensation for those who suffered because of the Bhopal gas leak, because enough time has passed. In fact, representing Union Carbide is Mr. Harish Salve, who says if tomorrow I can approach the court and file the review petition saying that millions of dollars of fine which was imposed on me, it has adversely affected me, so you should, instead of increasing it, decrease it. Will the government accept that? So it's a very tricky case. But the point is, ideally, review petition is to be filed within 30 days of your dismissal of the petition. Curative petition is also a review petition. So ideally, it should also be filed within 30 days of the dismissal of the review petition. But in some cases, if you can convince the court that there is a delay in me filing this review or curative petition, and these are the reasons for my delay, if the court is satisfied, you can file the curative or review petition even after the lapse of 30 days. What happened if the judge has retired or is unavailable? There will be judges in the Supreme Court all the time. So the senior most judges will hear this curative petition. And that is why senior judges are hearing this curative petition. Only after review petition verdict, there can be curative petition. Yes. After the umpire has given you out, then you can go for review. There is a leg before appeal. The umpire is not giving you out. The bowler can appeal, but batsman cannot appeal. I am appealing. There is no judgment, my dear. I am not giving you out. Why are you wasting your DRS? Okay. Now let's look at public interest litigation. And in this public interest litigation, we will look at what is the concept of judicial review, what is judicial restraint, what is judicial activism, what is judicial overreach or judicial adventurism, what is judicial evasion, and what Pratap Banu Mehta calls what is judicial barbarism. All this we will discuss in this concept, public interest litigation. But to understand this public interest litigation, we need to understand the Society of India. Society of India in the sense, with hand on your heart, tell me, before you attended these classes, were you aware of Constitution? Were you aware of the fundamental rights that are available to you? Were you aware of the remedy if your fundamental rights are violated? Most of you would not be aware. And I'm talking about those people who are educated, who are literate. So even if you are educated, even if you are literate, even if you can read and write, but the judicial literacy is very poor. Judicial literacy in the sense, people aware of their rights and the remedies available if these rights are violated. That is very poor in India. Even if you are aware, even then you are poor. You have no means of getting access to a good lawyer because the lawyers charge hefty fee, lakhs and lakhs of rupees per hearing. So even if you know that I have the rights which have been trampled upon by the state, violated by the state, but I cannot hire a lawyer because I'm poor. What am I doing then? I am getting my fundamental rights violated every day and out. And this is where an interesting question of public interest litigation originated. What happened? Hussain Ara Khatun and Kapila Hingorani. Kapila Hingorani, she was an advocate. In fact, her portrait is there in the Supreme Court today. She died a few years ago, and as a mark of respect, her portrait is hanged on the walls of the Supreme Court of India. Kapila Hingorani, she was reading newspapers. And by reading newspapers, she stumbled upon a newspaper article which talked about the condition of under trials in Bihar. Who are these under trials? For example, this is jail. In this jail, we have convicted people. We have under trials as well. I committed murder. Matter went to the court. The court said you are guilty. You are sentenced to life imprisonment. I am now in the jail, serving life imprisonment. Who am I? I am convicted. I have been declared guilty by the court. But I am accused of murder. The case is still going on. But where am I? I am inside the jail. Manish Sisodia, for example, is he convicted? No, he is only an accused. But where is he? He is in the jail. So he is in the jail as an under trial because the trial is going on. The trial is ongoing. Once you are convicted and you are sentenced to jail, then you are convicted. You are serving your punishment. Kapila Hingorani was reading newspaper articles, and in these newspaper articles, the plight of under trials was mentioned. What was their plight? There were some under trials who were serving more time in jail than they would have spent if convicted. What does that mean? I am accused in a particular case for which, let's say, the punishment is 2 years. Clear? I am accused of a case of an offense for which the punishment is 2 years. Where am I? I am in the jail. The first fundamental golden rule of criminal justice system is you are innocent until proven otherwise. You are innocent until proven guilty. So I may be innocent, but be that as it may, Even if I am guilty, then for how many years should I stay in the jail? 2 years. But there are some under trials in Bihar who are serving 3 years in jail, 4 years in jail, 5 years in jail, 7 years in jail. That means I am serving more time in the jail as an under trial than I would have spent if I was convicted. I am serving 7 years in jail as an under trial. The case is going on. Sunny Deol is right. Tariq pe tariq pe tariq. The case is not being heard by the court. I am an under trial. If my case would have been decided, I am serving 7 years in jail. For 5 years, I should have been set free. For 5 years, I would have been open. Because the maximum punishment is only 2 years. But I'm serving 7 years as an under trial. Kapila Hingorani, when she read this newspaper article, she approached and directly approached the Supreme Court. And there were 2 judges who were hearing this case. Justice P.N. Bhagwati, Justice Krishna Iyer. And who was Justice Krishna Iyer? He was previously a politician. And that speaks volumes about what collegium system has done in India. Justice Krishna Iyer, he was previously an MLA. He became a minister, law minister under EMS Namboodiripad when there was a communist government in Kerala. But then this communist government was dismissed when president's rule was imposed in 1959. And then Mr. Krishna Iyer, he was previously a lawyer. He joined the bar again. Not that bar. Bar means where you are serving judiciary, where you are taking up the cases. He served the bar, participated in the judgments, was an advocate, and later on he was recommended as the judge of the Kerala High Court. Later on he was recommended as the judge of the Supreme Court. So a politician as the judge of the Supreme Court, an ex-politician, an ex-MLA, an ex-minister as the judge of the Supreme Court, and he is today known as the most upright judge that India has ever seen. His judgments are cited by International Court of Justice. And India is not unique in this case. Mr. William Howard Taft, he was the president of the United States of America. Later on, he became the Chief Justice of the US Supreme Court as well. So being part of politics, having a political ideology is not a disqualification. You can be a politician, after that you can be a judge, it's completely fine. But while you are on the seat of the judge, you have to give honest, dispassionate, and real judgments. Long story short, Supreme Court heard this matter. Kapila Hingorani, Justice Bhagwati, Justice Krishna Iyer were part of the bench. And you know what they did? They did not ask Kapila Hingorani, what is your locus standi? Normally, who files a case? Somebody who is an aggrieved individual. My rights have been violated. I can approach the court. My dignity has been violated. I can approach the court. My lord, my dignity has been violated. Kapila Hingorani is filing this case in the Supreme Court of India, not on her own behalf, on behalf of these under trials in Bihar. The court did not ask Kapila Hingorani, how are you connected with these under trials? Are these your family members? Are these your friends? Who are you? Why are you filing this case? The court did not ask. The court said, Ms. Kapila Hingorani, we salute you for approaching us. We will not ask you how are you related to this case because you are filing this case for the larger public interest. You don't have any personal interest in this case. You are filing this case for a larger public interest. And this became the basis, the foundation of public interest litigation, where any public spirited individual can approach the court, file a petition of public interest litigation, not for her personal interest, but for the larger public interest. And because of this judgment, the Supreme Court ordered the release of 40,000 under trials in different jails of this country. And the first person to be removed, to be released from the jail was Hussain Ara Khatun. And that is the origin of public interest litigation. Where if there are individuals who are part of our society, but they are marginalized communities, they belong to weaker sections of the society. Number one, they don't know that they have rights. They're not aware of their rights. They're not aware of their remedy. Even if they are, they can't get lawyers for hefty fee, then what can happen? An NGO can come, Mr. Prashant Bhushan can come, Kapila Hingorani can come, and they can file a case on behalf of these marginalized, weaker sections of the society, and that is known as public interest litigation. And in this public interest litigation, there is no concept of locus standi. The court will not ask you, who are you? Why are you filing this case? What is your locus standi? And such cases are filed mostly when fundamental rights are violated. And this became the basis of public interest litigation. And something else happened later on. What happened? There were law professors. They had to conduct a survey at the Agra Reform Home, where women prisoners were kept. They conducted research, visited Agra Reform Home, and realized that women are being sexually assaulted inside that reform home. When this article was published in the newspaper, the Supreme Court took this matter suo motu on its own. Nobody approached the Supreme Court. Nobody filed a petition before the Supreme Court. But this paper, which was published by the law professors, which talked about the harassment and the sexual harassment of women prisoners in the Agra Reform Home, when the Supreme Court judges read that newspaper article, they said, it is this newspaper article which is like a petition, and we will take this matter on our own. This became public interest litigation. Recently, a 4-year-old boy was mauled by the dogs in Hyderabad, and ultimately he passed away. The Supreme Court read that newspaper article from the Hindu newspaper. It was on the front page of the Hindu newspaper. Not Supreme Court, the Telangana High Court read this matter in the Hindu newspaper and converted this newspaper article into a public interest litigation. Similarly, there was a prisoner. He was a prisoner in Delhi, but he was a political prisoner. Political prisoner in the sense for political grievances, he was arrested. But now he is asking for pen, he's asking for notebook, he's asking for copies, so that he can write his daily instances, daily dealings. He sent a postcard to a judge, not a petition, postcard to a judge. The judge saw that postcard and converted that postcard into a public interest litigation and called for jail reforms, that there should be reforms in the jail. And it was because of this public interest litigation that Supreme Court said jail is an exception. Bail is the norm. As much as possible, release individuals on bail. Why? Because you are innocent until proven otherwise. If you are to be kept in jail, for that strict conditions should be met. What are these strict conditions? Either you are at flight risk. If we don't keep you in jail, you will take the first flight and run away from this country. And like Nirav Modi and others, we will never get back to you. If you are a threat to witness, there are witnesses in your case, and if we release you, you may threaten them, coerce them into not giving witness against you. Then keep this individual in jail. Third, if you can tamper with the evidence. So this person is accused of murder, but we have not yet found the murder weapon. If we release him on bail, he may go and take a look at that murder weapon and destroy it, tamper with the evidence. Please don't release him on bail, keep him in jail. If these conditions are not there, if I'm not at a flight risk, if I cannot tamper with the evidence, if I cannot threaten the witnesses, then release me on bail, because bail is my right. Jail can only be an exception. Who said this? Supreme Court in public interest litigation. And if you have looked at Article 19(1)(a) of the Constitution or Article 21 of the Constitution, we call them most evolved fundamental rights. Article 19 is the second most evolved fundamental right. Article 21 is the most evolved fundamental right. Most evolved in the sense, right to privacy is also a fundamental right. Right to livelihood is also a fundamental right. Right to dignity is also a fundamental right. Right against solitary confinement is also a fundamental right. Right to travel abroad is also a fundamental right. Right to ask questions to the candidates contesting elections is also a fundamental right. Right to express your love for your national flag is also a fundamental right. All this was possible because PILs were filed, because public interest litigation was filed. And the court did not ask, what is your locus standi? How are you connected with this case? So it is because of this concept of public interest litigation that common people have got access to the courts to obtain legal redress. For the redressal of their problems, for the redressal of their grievances, common people, they have now access to the courts through NGOs, through public spirited individuals. I'll spend my own money and I will file a case on your behalf. That's how marginalized people, poor, got access to justice. Similarly, it's an important instrument of social change for maintaining rule of law and for accelerating the balance between law and justice. How? All those under trials are released from the jail, giving justice to them. All those women prisoners, they need to be protected. And now regularly what will happen? The Supreme Court will send its men, its judges, or the high courts will send their judges to periodically visit these jails and see if the condition of the inmates in these jails is good or bad, whether they are discriminated against or not. So this calls for a social change. It's because of this PIL that justice has become accessible to marginalized, the poor, and the disadvantaged sections of the society. It's because of this PIL that human rights have reached those who were denied human rights, who were denied dignity in the jails. The significance of PIL is it has democratized access to justice. Any citizen or organization who is capable can file petitions on behalf of those who cannot or do not have the means to do so. It helps in judicial monitoring of state institutions such as prisons, asylums, protective homes, because now judiciary will monitor, will visit these jails periodically and see if those individuals, those prisoners, those inmates are dealt with dignity or not, or if their dignity is violated inside the jail. Similarly, it's an important tool for implementing the concept of judicial review. So what is judicial review? Any action of the legislature, any action of the executive can be reviewed by the judiciary. So if there are prisoners kept in jail for more years than the punishment for which they have been arrested, for the crimes they have been arrested, judiciary will review and release them. So to understand this PIL, it has enhanced public participation. Public participation in the sense, 2G scam was unearthed when a public interest litigation was filed. Coal scam, it got unearthed when PIL was filed. Adarsh Housing Society scam, Commonwealth Games scam. All these scams got unearthed when public interest litigation was filed in the Supreme Court. When the public interest litigation, when NGOs or publicly spirited individuals approached the court and asked the courts that there is some problem with the organization of the Commonwealth Games. Can you please investigate this matter? And that's how we got to know that there is corruption involved. Dear Supreme Court, the way 122 2G licenses have been issued by the central government to these private players, there is an element of corruption involved. A public interest litigation was filed. Supreme Court ordered the investigation and ultimately revealed that these 122 2G licenses should be cancelled. That is the power of public interest litigation. So long story short, what is public interest litigation. The concept is any public spirited individual or an organization can approach the court. And which are these courts? PIL can be filed only in the court of record. PILs can be filed only in the court of record, which means PILs cannot be filed in the district court because district courts are not court of record. PILs can be filed only in the high courts and the Supreme Court. That's concept. The concept is court will not ask what is your locus standi. How are you related to this case? How are you connected with this case? The court will not ask this matter. Any public spirited individual, any organization for the larger public interest, for weaker sections of the society, marginalized sections of the society, deprived sections of the society can approach the court and file petition on their behalf. And that is what is known as the public interest litigation. And the origin is the Hussain Agha Khatun case or Kapila Hingorani. And what are these rules, purposes, criticism, and new rules? Let's discuss. This public interest litigation, it's like a twin-edged sword. It has some advantages as well. It has some disadvantages as well. Advantages we have discussed, how it has enhanced public participation in judiciary, how some scams have been unearthed, how Article 21 and Article 19 got expanded because of public interest litigation, how particularly environment-related cases where Supreme Court said right to pollution-free environment, right to clean environment, right to healthy environment is also a fundamental right. All this became possible because of public interest litigation. But it has a dark side to it as well. It has a flip side to it as well. And this is where some people say, is it public interest litigation? Or is it private interest litigation? Or is it personal interest litigation? Or is it publicity interest litigation? Just as a weapon meant for defense can be used equally effectively for offense as well. There is a weapon. I have a knife. I can use it to cut veggies, fruits. I can also use it to kill you. In the similar fashion, we have lowered the concept of locus standi. That means now anybody can approach the court, even if you are not connected with that case, even if you are not party to that case, even if your rights have not been violated. It will permit privately motivated interests. What they can do, they can pose as public interests. Public interest in the sense, in Gujarat, two businessmen approached the Supreme Court. My lord, public interest litigation. Said, very good, come here. What is this public interest litigation about? Sir, there are asbestos factories in Gujarat. Yes, causing pollution. Really? Affecting the mindset of the children particularly. Their cognitive abilities will be destroyed if we will allow these asbestos factories in Gujarat, in those areas where children are residing. I said, wow, so beautiful. You are so publicly spirited individuals. You have left your business and you have come here for the larger public interest. Wow, you're so beautiful. But in these PIL matters, the court appoints amicus curiae. Who is this amicus curiae? The friend of the court. Because a party has approached you. Now somebody has to assess the court whether what do we do in this matter. The court appoints an amicus curiae, the friend of the court. You are our friend. Can you please help us? How do we deal with this case? This amicus curiae, when he did some bit of research, reached the Supreme Court again and said, dear Supreme Court, do you know what? I said, what? These two gentlemen, whom you are calling publicly spirited individuals, who are approaching the court on behalf of poor, marginalized students and kids because their cognitive abilities will be destroyed if asbestos factories are allowed to function in Gujarat. Do you know what they do? They manufacture an alternate to asbestos. I said, really? So you are cloaking and you are clothing your public interest litigation, but within public interest is your personal interest. The Supreme Court imposed a cost on these two businessmen saying, if you do this again, you bring your personal matter as a public interest, we will throw you to jail. Dr. Subramaniam Swamy, with no offense, approaches the court, files a public interest litigation. Why? There should be a CBI investigation into the killing or alleged killing of Sunanda Pushkar Tharoor, the wife of Dr. Shashi Tharoor. She unfortunately passed away under mysterious circumstances in a hotel in Delhi. I think it was the Leela Palace Hotel in Delhi. She passed away, and then there was an allegation that maybe she was murdered. Police conducted the investigation, and it was realized that there is no such thing as murder. She was already suffering from some ailment, whatever it is. But Dr. Subramaniam Swamy says, approach the court and file a public interest litigation. There should be a CBI investigation into the death of Sunanda Pushkar Tharoor. What was the principle on which PIL was introduced in India? To protect the interests of the marginalized communities, to safeguard their fundamental rights. What public interest will be served if we have a CBI investigation into the death of Sunanda Pushkar Tharoor? There should be investigation, no doubt, but why are you approaching the court and filing a public interest litigation? It seems that this is not public interest litigation, this is publicity interest litigation. And through this publicity interest litigation or private interest litigation or personal interest litigation, what are you doing? You are wasting the precious time of the court. And that is why the cases keep on piling in the Supreme Court, because the court is unable to hear these cases because PILs are approaching. And these PILs, if they are genuine, very good, we will accept them. But these are private interest litigations. These are publicity interest litigations. These are personal interest litigations, clogging the court, violating the time, the precious time of the court, and destroying it. Then over a period of time, interesting PILs have been filed. A PIL was filed in the Delhi High Court saying Prime Minister's Facebook page, it shows a distorted picture of the national flag. Please ask the Prime Minister to correct it. Okay. PIL was filed against Yo-Yo Honey Singh, that the lyrics and the songs are vulgar, ban them. If the songs are vulgar, if the lyrics are vulgar, don't listen, don't hear, close your eyes, switch on off your TV, uninstall Spotify, don't watch, don't read, don't hear, don't do anything. A public interest litigation was filed against Jism 2 for promoting a call girl featuring the former porn star Sunny Leone. Ban it. Why? You don't want to watch it, don't watch it. So this is not a public interest litigation. This is a publicity interest litigation, because even after so many years, we are discussing this case. Interestingly, a PIL was filed against film Shanghai, saying that there is a song which denigrates Bharat Mata. It says, Sone ki chidiya, dengue, malaria, good bhi hai, gobar bhi, Bharat Mata ki jai. Ban this song. A petition was filed that Miss World contest should not be conducted. A petition was filed that Mr. K.R. Narayanan should not contest for the post of the President of India. A petition was filed against Mr. What's his name? Mr. Dhanush, that your song Kolavari Di is offensive. It should be banned. Now the point is, public interest litigation, which was meant to give access to justice to weaker sections, marginalized sections, when their fundamental rights have been violated. And the concept says there is no concept of locus standi. That means anybody can approach the court for the larger public interest. But this larger public interest, who decides what is this larger public interest? The court. That means first the matter has to reach to court, whether there is any public interest involved or not. But now people are coming up allegedly filing public interest litigation. But beneath that public interest litigation is their personal interest, is their private interest, just like those two businessmen. Beneath this public interest litigation, there is your desire for publicity, publicity interest litigations. And thereby what you're doing, you're choking the time of the court. And that is why the cases keep on piling in the court, because the court give preference to public interest litigation, which they should, but in the process, the courts are unable to spend time on the real cases which are pending. And that is how new guidelines were issued to prevent the misuse, the abuse of filing personal interest litigations or publicity interest litigations or private interest litigations. Rule number one, the courts must encourage genuine PILs and discourage others. Genuine PILs and discourage others. The court should verify the credentials of the petitioner. Who is this petitioner? Every time he comes up with these frivolous petitions, now we will not accept your personal interest litigation or public interest litigation. Substantial public interest should be involved. Substantial public interest. That means you can't file a PIL on the grounds that my salary has not been released or the salaries of Anganwadi workers has not been released. You should talk about something substantial, something violating fundamental rights. For example, street vendors are evicted and alternate accommodation is not provided to them. That is a substantial interest. A substantial interest can be if there is a demolition drive going on, but people are not given notice before demolishing their houses. That is a substantial public interest. A substantial public interest is if there is a grave corruption allegation against a particular deal. For example, the Rafale deal. A PIL was filed. Later on, Supreme Court rejected this, but it was a genuine PIL. Why? Because to see if there is an element of corruption. Substantial public interest should be involved. And if we realize that this petition you are filing is basically private interest or publicity related petition, then costs will be imposed on you. And that is how almost on a regular basis, if you read newspapers, Supreme Court imposes 50,000 fine on a PIL petitioner. Supreme Court imposes 20,000 fine on a PIL petitioner to discourage them from filing these frivolous petitions again and again. So these new guidelines will go a long way in preventing the misuse, the abuse of this beautiful weapon, which is there for public benefit, known as public interest litigation. Any questions? If the road is not constructed and due to that public is suffering, then can it be a PIL? Yes, you can file a PIL. For example, in CAA protests, against the CAA protests in Shaheen Bagh, that area, an important road was blocked by the protesters. A PIL was filed in the Supreme Court asking the Supreme Court to give a directive that this road should be vacated, don't hold protest there because you are causing inconvenience to the larger public. It is a public interest litigation. Can PIL be filed in high courts? Yes. Can family pension cases be filed under PIL? No. Can we file PIL against reservation? Yes. PIL, you can file directly in the Supreme Court as well. You can go to the High Court as well. Is PIL without public interest considered contempt of court? No. What is the scope of review petition? Scope in the sense to correct an error which has been given in the judgment. That is why basically if your decision, if the Supreme Court order says you are guilty, you hang by your neck till your death, but you file a review petition and the court accepts this review petition saying new fact has emerged. We thought that you are a murderer, but now the new fact says the other person is the murderer. You are set free. That's the scope of review petition. PIL is not mentioned in the Constitution. Does publicly criticizing collegium amount to contempt of court? If you are criticizing collegium on facts, then it is not a contempt of court. But if you are scandalizing the court that all these collegium members, they appoint only their own members, their own family members as judges, then you are scandalizing them. Unless and until you have proof, you can't do that. Writ jurisdiction of High Court is wider than the Supreme Court? Yes. Now let's look at what is this judicial review. Maybe you know what is a judicial review. Basically, the action of the legislature, action of the executive can be reviewed by the judiciary to see whether it is constitutional or unconstitutional. But what if the question is asked in your mains examination, what is judicial review? And do you think the power of the judicial review is part of the basic structure of the Constitution? Comment in line of recent Supreme Court cases. For that, you should know what to write in this topic. What is judicial review? So please take a note of this definition. Power of the courts of a country to examine the actions of the legislative, executive, and administrative arms of the government, and to determine whether such actions are consistent with the Constitution. Actions judged inconsistent are declared unconstitutional and therefore null and void. The institution of judicial review, in this sense, depends upon the existence of a written constitution. This is the most important line that you have to write in your answer. Why? Because in Britain, they have an unwritten constitution. And in an unwritten constitution, who is more powerful? Parliament. Parliament is sovereign. Parliament can do anything. The role of the judiciary is less. But in a written constitution, where we talk about independence of judiciary, where we talk about supremacy of the constitution, independence of the judiciary says judiciary will have the power to review any action of the executive, any action of the legislature, to check whether it is constitutional or not. That is the definition of judicial review. But initially, when judiciary would practice judicial review, it was exercising a restraint. And that is how the term came to be, judicial restraint. What is this judicial restraint? There is a case pending before the court, and there is something known as presumption of constitutionality. For example, if you challenge Citizenship Amendment Act in the Supreme Court, the court will assume that this law is constitutional. The courts will presume that this law is constitutional. It is for you to convince the court that this law is unconstitutional. That means the burden is on the petitioner. You have to prove through your arguments that this law is unconstitutional, because we will assume that the law is constitutional. We will presume the law is constitutional. Judicial restraint is whenever judiciary practices judicial review, it will exercise restraint. That means every now and then it will not declare the law passed by the parliament as unconstitutional. It will not declare the actions of the executive unconstitutional unless and until it is blatantly unconstitutional. That means the courts will give benefit of doubt to the executive and the legislature. Since the legislature is elected by the people, and through people they are making the laws, we should not strike down these laws unless and until these laws are blatantly unconstitutional. Blatantly unconstitutional in the sense, if this law says, for example, there should be death sentence for every accused, you can't give death sentence to an accused. You can give death sentence to a convicted. So this is blatantly unconstitutional. We will strike it down. But if it says that for every murderer who has been convicted, there should be mandatory death sentence, the courts will exercise restraint and say, okay, it is possible, the law is constitutional. If the executive has made some rules, the court will exercise restraint and will basically say, we will not interfere, please go ahead. So this role of the judiciary to exercise restraint, this restraint is basically something which happens when there is a strong government in power at the center. For example, 1950s, initial years of India's republic, judiciary exercised restraint. Restraint in the sense, first Constitutional Amendment Act was passed, which was challenged in the court. The court said it is constitutional. Ninth schedule was added to the constitution. Matter went to the court said it is constitutional. Article 15 was amended, the court said it is constitutional. Article 19 was amended, the court said it is constitutional. Article 31 was amended, the court said it is constitutional. Various changes were made to the constitution, various laws were passed, and ultimately the court said it's constitutional, constitutional, constitutional. Judiciary is exercising restraint. But when judiciary started asserting itself and declaring the laws passed by the parliament as unconstitutional, laws passed by the state legislature as unconstitutional, actions of the executive as unconstitutional, over a period of time, judiciary practiced something known as judicial activism. What is this judicial activism? Let's take a look at some cases. What are these cases? Case number 1. Appointment of governors and their role. Is the power of the governor that I can refuse to summon the legislative assembly on the date which is recommended by the chief minister and council of ministers? Matter goes to the court says no, governor does not have this power. So judiciary is now becoming an activist. Activist in the sense, judiciary is now assuming the role of an activist and will stop anything which the legislature or executive is doing if it is unconstitutional, or even if it's bordering unconstitutionality. Judicial activism in the sense. Vishaka guidelines. There was one lady, Bamri Devi, in Rajasthan. She was a social worker, but she was also a government employee. She was recruited by the government to take a look at how we can control the menace of child marriage in Rajasthan. Because there is an auspicious festival coming up, and on this auspicious festival, there are lots and lots of child marriages which are solemnized. Please ensure that you are convincing the villagers not to go for child marriage. She was from a lower caste, or so-called lower caste. No such caste is high or low, but she was from so-called lower caste. And then she started convincing the members of the so-called upper castes that you should not go for child marriages. Some members of the upper caste did not agree and did not like a lady from the lower caste preaching them whether they should go for child marriages or not. And Bamri Devi was raped in full public view by 5 men. When she was raped, matter went to the court, Rajasthan High Court. Rajasthan High Court said all these 5 people are innocent. Why? Various arguments were given, but 2 arguments strike out. Argument number 1 was that Bamri Devi's husband was also there when she was being gang raped by 5 men, or allegedly gang raped by 5 men. But this individual is also well built. Her husband is well built. Why did he not fight with these 5 men? Why did he not fight despite the fact that he is well built? Why did he not save the honor of his wife? So we can say that rape did not take place. Otherwise, he would have fought. And out of these 5 accused, one is the uncle, the other is nephew. In Indian society, we will never imagine an uncle is having sex in presence of his nephew, or nephew is raping somebody in presence of his uncle. So these are the circumstances on which we can say that rape never happened. The rapists of Bamri Devi were set free. One organization, Vishaka, approached the Supreme Court in 1997 saying, this is my public interest litigation. Said, what are you trying to do? My lord, legislature has not passed any law to prevent sexual harassment of women at workplace. Who was Bamri Devi? Bamri Devi was a government employee. What was Bamri Devi doing? She was working. She was at a workplace. She was convincing the members of Rajasthan community that you should not go for child marriages. There is no law in India, absolutely no law in India which prevents the sexual harassment of women at workplaces. The Supreme Court said, don't worry, we will issue these guidelines. And these guidelines became Vishaka guidelines. How can we prevent the sexual harassment of women at workplace? This was in 1997-98. It was only in 2013 that sexual or anti-sexual harassment law was passed. That is judicial activism. Why? Because this Vishaka guideline is like a judicial legislation. Who makes a law? Legislature. But this time, who is making a law? Judiciary. What is this? This is judicial legislation. Is judiciary having the power to make a law? No. This violates separation of powers. Yes. But even then, this is good. Why? Because judiciary is playing the role of an activist. What sort of an activist? When legislature is failing to do its job, when the executive is failing to discharge its duty, then what should be the Supreme Court doing? Should it sit like a mute spectator and not interfere at all? When the legislature has failed in its duty, when the executive has failed in its duty, then the onus is on the judiciary to become an activist and legislate. That is what is called judicial legislation. This is not wrong. This is right. Why? Because under Article 142 of the Constitution, the Supreme Court can give any order so as to give complete justice. And under Article 141 of the Constitution, any judgment passed by the court is the law of the land. Something else happened. Lokayukta was to be appointed in Uttar Pradesh. Chief Minister was Mr. Akhilesh Yadav. Clear? Lokayukta is to be appointed. Matter went to the court. My lord, Lokayukta has not been appointed. Is there any public interest involved here? Yes. Because there has to be a body which will be responsible for investigating corruption allegations against the chief minister, against his ministers, against the members of the civil services. We need a Lokayukta. The court said, yes, a larger public interest is involved. We will hear this matter. Governor, chief minister, come here. Why are you not appointing a Lokayukta? Sir, we will appoint. But chief minister and governor, they were in clash. Chief minister is recommending a name, governor is not accepting. Governor is recommending a name, chief minister is not accepting. The courts lost patience. Said, one last chance. Take up the matter. Appoint Lokayukta. Not appointed. Who has the power to appoint Lokayukta? Governor. That means it's the executive power. Executive is failing to discharge its duty. The court said, enough is enough. We will appoint the Lokayukta. So this is judicial activism. What is judicial activism? The tendency of the court to act when one or the two organs of the state, they have failed to discharge their duty. And the courts become like an activist and impart justice, complete justice under Article 142 of the Constitution. So legislating through a judicial order known as judicial legislation, Vishaka guidelines, judicial activism. Appointing Lokayukta in Uttar Pradesh, judicial activism because the executive has failed to discharge its duty. Another example of judicial legislation, student elections in universities and colleges. For a long time, the case was in the court that in these university elections, student union elections, lot of muscle power, lot of money power is used. Muscle power in the sense, gundas from various political parties, they come and pressurize the candidates, don't contest election, our candidate will contest the election, you should vote for him, not vote for him, Sanju Bhai. Muscle power, money power, lakhs and lakhs of rupees being spent as bribe to the voters. Come, I'll take you to the cafeteria, chicken biryani, mutton biryani, any biryani, vada pav, whatever pav, but vote for us. This money is coming from the political parties. And through this money power, through muscle power, we are violating the sanctity of student elections. Court said, what can we do? This is the job of the parliament. This is the job of the government. Let's see what they have to do. The government is not doing anything. Legislature is not doing anything. The court said, enough is enough. We know one guy. Who is that guy? J.M. Lyngdoh. Who is he? He was previously the chief election commissioner. Mr. Lyngdoh, come. You have now retired. Now we will give you a job. Come here. You define how student elections should be conducted in India. How can we eradicate the menace of money power, the muscle power? You also can decide those who are contesting student elections, they should have a minimum attendance criteria. That means there are so-called students who want to contest elections, because once you contest student elections, quickly you become a popular figure, and quickly you can become the leader of the political parties as well. You can become ministers. Mr. Arun Jaitley, Mr. JP Nadda, all these important leaders, they originated from the student politics. So there are students whose primary intention is to contest elections. They enroll in a university without attending the classes. They are contesting the elections because their intention was never to attend the classes or gain education. Their intention was to form a students union. Such individuals should not be allowed to contest election. Minimum education, minimum attendance should be prescribed. Minimum marks should be prescribed. You should not have a backlog in any semester. If you have the backlog, you cannot contest elections. Who decided this? JM Lingdo, on the recommendations of the Supreme Court. What is this? This is a judicial legislation. Why? Because when the state failed to discharge its duty, when the legislature and executive is not acting on its own and thereby forcing the judiciary. So judicial activism is not something which the court does on his own, on his liking. It is thrust into the unwilling throat of the judiciary because it cannot remain mute spectator when the governance takes a hit, when legislature is not doing its role, when executive is not doing its role. That is judicial activism. So judicial review, what is it? We know that. Clear? And through public interest litigation, when the judiciary practices judicial review, ultimately justice is given, fundamental rights are expanded. But judiciary in the initial years of republic exercised restraint. Restraint in the sense, as much as possible, the laws passed by the parliament, actions of the executive should not be declared unconstitutional unless and until they are blatantly unconstitutional. But then over a period of time, judiciary started becoming restless. Restless when the legislature is failing to discharge its duty, when the executive is failing to discharge its duty, and when important matters reach to the Supreme Court through public interest litigation, it cannot sit like a mute spectator. It has to act. And when he acts, when the court acts, it practices judicial activism, taking away the role of the executive by appointing the Lokayukta, taking away the role of the legislature by legislating Vishaka guidelines, Lingdo committee recommendations. But then, my dear, there is a thin line between judicial activism and judicial overreach or judicial adventurism. Because once you cross this line multiple times, when you multiple times take away the role of the executive, when you multiple times take up the role of the legislature, you are violating the separation of powers. And it is this separation of powers which, dear Supreme Court, you have said is also part of the basic structure of the Constitution. And this is where we will now have to look at some of the interesting, or should we say disturbing, trends of judicial activism. What is judicial activism as a definition? If you have to write, judicial activism is an approach to the exercise of judicial review or a description of a particular judicial decision. When judiciary gives a decision, you can say this is judicial activism, in which a judge is generally considered more willing to decide constitutional issues and invalidate legislative or executive actions. And what are the disturbing trends? I will go back to these previous slides in a moment, but first let's look at the disturbing trends, then we will go back to the previous slides. Trends such as in Delhi, the space for car parking was less. Okay. Matter went to the court. Public interest litigation was filed. What court did? Court imposed parking fee. Parking fee, We will see the reduction in the number of cars which will be parked on the public places. That's how we can solve the menace. Okay. My lord, another public interest litigation. What is it? Monkey menace. There are monkeys swarming the public places in Delhi, in Chandigarh and others. Supreme Court said, don't worry, we will issue guidelines, and through these guidelines, we can solve monkey menace problems in India. Okay. My lord, public interest litigation. Yes, please come. What is the issue? Sir, during monsoon, we have water in South India. Non-monsoon period, or when the monsoon fails, the water level goes very down, and then we are not able to irrigate our lands. Northern states also said the same thing. Some petitioners from North India, some petitioners from West India. The court said, okay, so do you know what we will do? We will interlink rivers. So all the rivers that we have in India, we will interlink them, so that rivers in northern India, when they have good water, enough water, this water will flow to the southern India as well. We will interlink the rivers in India. Such a complex exercise, which even the experts don't know how to do. But judiciary is ordering interlinking of rivers. Okay. My lord said, what? A public interest litigation. Very good. Come. What is the matter? Sir, on highways, lots of accidents happen. I know. So do you know why these accidents happen? Why? Sir, because of drunken driving. Because on these highways, we have liquor shops. So a driver goes to a liquor shop, consumes liquor, and then drives, and then hits passengers, and this is where the deaths take place. You're right. What do we do now? All the liquor shops within the 500-meter radius near the national highway should be closed. Okay, sir. Another case. Hazrat Bal, a shrine in Jammu and Kashmir. The terrorists attacked the Hazrat Bal shrine, and the terrorists were housed there for many days. They also took some of the individuals hostage, some of the civilians hostage. Then army, police, and others, they decided to come together, and they conceptualized an idea, how do we deal with these terrorists? Army said, let's do one thing. Said, what? Let's cut the food supply to Hazrat Bal shrine. Because when we send food to the civilians, this food is consumed by the terrorists as well. They get energy, and they remain there, persist there for a long time. Let's cut the food. Said, okay. Public interest litigation was filed in the Supreme Court. Supreme Court said, no, you can't do that. 1,200 calorific value of food should be given to the hostages every single day. This led to the then army chief remarking that it is this judgment which has severely dented this Hazrat Bal operation. No issues. PDS, public distribution system, PDS shops or fair price shops, where you go and buy wheat, paddy, any other item, pulses at subsidized rates. 1 rupee a kg, 2 rupee a kg, 5 rupee a kg. Matter went to the court, said there is corruption in PDS distribution system. Said we will monitor it. Dr. Manmohan Singh rarely spoke, but he spoke in this instance. He said, PDS is my responsibility. Don't snatch it from me. In all these cases, if you notice, fundamental rights are not involved. The court is getting entangled into purely administrative matters. There is no parking space in Delhi, prescribed parking fee. That's not your job. Go and first decide the constitutionality of Citizenship Amendment Act. Why are you wasting time in administrative matters, which is the job of the executive? And what logic do you have in prescribing interlinking of rivers when even experts don't know how to do this? In an ongoing military operation, you are coming up and saying 1,200 calorific value of food should be given. We will monitor public distribution system, monitor your own judges. Monitor your own registry. How are they setting up cases before the judges? These are the disturbing trends of judicial activism. And when these disturbing trends disturb us a lot, you are crossing the thin line of separation of powers, which is also part of the basic structure of the Constitution. So judicial activism is like a medicine which should be given only in small doses and whatever required. When you increase that dose, the patient dies. You disturb the whole edifice on which our Constitution is founded, which is separation of powers. And this is what judicial activism say over a period of time leads to judicial overreach, or what is known as judicial adventurism. And what is judicial adventurism? Collegium system. Some will say it is judicial activism because judiciary is now playing the role of an activist and removing the power of the executive in judicial appointments to safeguard the independence of judiciary. Some would say this is the classic example of judicial overreach, judicial adventurism, because where is collegium system mentioned anywhere in the Constitution? Where is it mentioned that president is bound by the aid and advice of the collegium? This is judicial adventurism. Hazratwal operation, classic example of adventurism. Andhra Pradesh High Court order on Article 356. Do you know what Andhra Pradesh High Court did last year? What is Article 356? If the president is satisfied on the report of the governor or even otherwise, look at how judiciary can interpret Constitution. If the president is satisfied on the report of the governor or even otherwise that there is breakdown of constitutional machinery in a state, president's rule can be imposed. A PIL was filed in the Andhra Pradesh High Court saying there should be president's rule imposed in Andhra Pradesh. Why? Because there is corruption. Why? Because there is law and order breakdown. Supreme Court said we will set up a committee and we will investigate and we will then decide whether we can recommend to the president that impose president's rule. We thought president's rule can be imposed on the report of the governor or on the basis of the report of the High Court. High Court was asked, but how can you say your report to the president will form the basis of the imposition of president's rule in Andhra Pradesh? The court said, look at Article 356. If the president is satisfied on the report of the governor or even otherwise means the report of the High Court as well. Luckily, this judgment was struck down, was stayed by the Supreme Court. But this is again a classic example of judicial adventurism. Rajasthan political crisis in 2020. What happened? Congress party, there was a rebellion within the Congress party. Sachin Pilot along with 13 of his MLAs rebelled. Sachin Pilot wanted to become the chief minister. Ashok Gehlot said, majority members is with me. The speaker of the Rajasthan Legislative Assembly issued a notice to Sachin Pilot. Why action should not be taken against you under anti-defection law? Because you seem to have defected. You seem to have voluntarily resigned from the membership of the Congress party. Sachin Pilot approached the Supreme Court. Supreme Court said, no, there should be dissent in a democracy. There should be dissent in a political party. My dear speaker has not disqualified Sachin Pilot. It is the job of the speaker to issue the notice. After speaker takes a decision, then you can review. But let him do his job. That is his job to issue a notice. Why get involved there? Get involved in the petitions which are 50,000 cases which are pending in the Supreme Court. Judicial adventurism. And the bizarre is 122 2G licenses. Atal Bihari Vajpayee was the Prime Minister. A policy was started known as first come, first serve. First come, first serve means we have the spectrum 2G, 3G, 4G, 5G. Any private player can come buy the spectrum. We will not auction. Whoever comes first, we will give him the auction. Dr. Manmohan Singh followed the same practice and issued 122 2G licenses. Matter went to the court. A PIL was filed. Supreme Court said, no, you cannot follow first come, first serve. You have to follow an auction. Dr. Manmohan Singh said, why auction? Do you know what happens in an auction? I have 122 2G licenses. I will ask all the bidders, bid for these licenses. Whoever bids the highest price, they will get the spectrum. But do you know they will pay the money? But who will have to face the brunt? The customers, the consumers. Their call charges will increase, their data rates will increase. I don't want revenue maximization. I don't want revenue to be maximized because of the auction. What I need tele density. By selling 122 2G licenses, I don't want revenue for my government. I want the call rates to drop to such a level, data rates to drop to such a level, so that every single Indian will have a smartphone, will have a phone which they can use. I want tele density to increase in India. And after all, it's a policy decision. My policy is that we will not go for revenue maximization, we will go for tele density. And for that, my policy is first come, first serve. And you are saying auction? Who are you? It's for the people of this country to decide whether they like my policy or not. This is the policy domain. This is the domain of the executive. Please don't interfere. But the court said no, auction. This is the classic example of judicial adventurism, where judiciary is now on an adventure and usurping the powers of the executive and the legislature. This is a disturbing trend, because if it continues, it violates the separation of powers, which is also part of the basic structure of the Constitution. That is it for today. We'll meet tomorrow. We will revisit judicial activism. Then we will look at what is judicial evasion, what is the concept, why are there cases pending in different courts of this country. We will look at the structure of the high courts, district courts, and then tomorrow we will initiate the discussion on elections. Done? Criticism of judicial activism is it is usurping the powers of executive and legislature, thereby violating separation of powers. That's criticism number one. Criticism number two, the judiciary is getting involved in petty administrative matters, which is not their domain, ultimately entering into the policy matters, which is the job of the executive, and thereby focusing not on the cases which are pending in the Supreme Court, but focusing on these administrative matters, which leads to the increase in the number of cases pending in the court. And at the same time, judiciary is not competent in policy matters. Judiciary may be competent in law, in constitution, in CRPC, IPC, but will not be competent in deciding upon the policies. That should be the domain of the executive. Okay, thank you so much. See you tomorrow, 6 o'clock in the morning. Till then, have a great time. Bye-bye. All the best.